All right, so.
Zeros. Yes. So the capital H after the dollar sign might be what's getting it.
Batteries. The dollar sign. Okay. That's what I mean. Maybe I can get Ryan Moody one right there. All right, thank you.
Hey, yeah, be here. She'll be online. She's in Hawaii.
Hey, let's see if she's there. She's there. So
Taylor,
just
are you need to share the documents we printed with Kate? I need to share, the documents that all get entered into evidence. You'll just actually there. Is that how that works in real time?
Yeah, I'll scan it.
But you already have these digitally. I'll give it to you to scan.
Yeah, just so that it's not like everything's presented again.
Okay. Never mind.
all right. Good evening, everyone. This is a meeting of the Village of Shorewood. Are we ready to go? Not yet? This work? Hello? Does this work?
Very.
You guys like this? Do you have any other options than this? What about that one?
Take the mic. Usually when we change mics, we have a good luck. They just swap the mics around.
Oh, boy. Oh, that's gonna blind me.
No, can't you just put the mic here?
You just,
Yeah,
all right.
it's just full up, I think.
Okay.
They're just,
Okay, does this work? No. No. All right.
Take the
I can project.
Take the handheld. No.
I'll take the handheld. Thank you. Thank you, thank you, thank you. Thank you so much. All right. Is this working? Testing, testing, testing. Is this working? Does it sound good or muffled? All right, we're gonna have to project.
I'm gonna go online.
So that'll pick up online that area mic. Otherwise, it is
All right,
just close to the other mics.
okay.
can we move the area mic closer for the time?
Is this one working? It is. So you might want to switch seats, actually, Sean.
Just, I could talk loud. All right, so. Good evening, everyone. This is a meeting of the Village of Shorewood Hills Board of Trustees. Today is Tuesday, May 12th, 2026, and the time is 6:03 p.m. I'd like to call this meeting to order. Taylor, could you do the roll call, please?
Barford,
Here.
Lutterer,
Here.
Lotfie,
Here.
Olsvik,
Up there.
and then I will
She's muted.
unmute her.
Hello, I'm here and my video is also enabled, but I am here. If you want to enable my video, I'm happy to be on camera.
1 second.
Taylor, this is Kate Crowley. I think you enabling the wrong Kate.
Oh, thank you.
Got it. Thank you.
All right, Butchig,
Here.
Van Asten,
Here.
Imes,
Present.
Madam President Pro Tem, we have quorum.
Wonderful. So this hearing is being held because the village has received a verified complaint from Brian Utchik and Peter Hans pursuant to Wisconsin statute section 17.16 sub 3, which charges that Village President John Imes has engaged in gross neglect of duty. In response to receipt of this complaint, the village board is required to hold a speedy hearing on the charges, which we are doing tonight. May I have the appearances for the parties?
On behalf of President Imes, my name is Erin Deely.
Peter Hans, on behalf of the complainants.
Perfect. So the hearing, I'll just talk a little bit about the order and some housekeeping items. I'll be talking for about 10 minutes. So first, the hearing shall proceed in the following order. First, I will address some housekeeping matters. We will discuss recusal. There'll be opening statements by the complainants. Try to limit it to 3 minutes. There'll be opening statement by the respondent or respondent's counsel. Try to limit it to 3 minutes. We'll have a presentation of evidence by the complainants, presentation of evidence by the respondents, and a closing statement by each party. If you could try to limit it to 5 minutes, that would be great. And then there'll be deliberations. Housekeeping items. One, I believe we have a court reporter here. And so a written transcript of this hearing shall be made available. Any party requesting a copy of the transcript shall be entitled to one. This is an evidentiary hearing. It is not a court of law. So strict adherence to rules of evidence is not required, but the board shall admit evidence that is relevant, material, and reasonably reliable. The next item. The party presenting the charges, the complainants, bear the burden of proof. And the standard of proof in this proceeding is preponderance of the evidence. So that means the evidence must demonstrate that it is more probable than not that the respondent committed the alleged gross neglect of duty. Number 4, all documentary exhibits shall be marked for identification. And if you guys could do that by providing your exhibits to Attorney Nelson for submission into the record, that would be great. If there are witnesses, the witnesses shall testify under oath. I'm not sure if there are any. And then if at any time anybody needs a break or a recess, just please let me know. And if I could just ask people to mute your phones, that would be great. So I'm going to read a preamble next. The Board of Trustees convenes this hearing in fulfillment of its solemn legal and ethical duty to the institution it governs, to the public it serves, and to the rule of law. This proceeding is not undertaken lightly, nor is it undertaken with any spirit of animus. It is undertaken because the integrity of public governance demands that charges of gross neglect of duty be examined with rigor, transparency, and fairness. Every member of this board is bound by an oath to act in the public interest, to uphold the law, and to exercise independent and impartial judgment. These instructions are designed to ensure that this hearing reflects those values at every step, that the process is lawful, that the evidence is weighed honestly, that the respondent is treated with full dignity and due process, and that the board's ultimate decision rests solely upon the weight of the evidence and the applicable law. Each trustee should approach every phase of this proceeding with intellectual humility, openness to persuasion, and an unwavering commitment to the truth. Now, the legal requirements. So it is my understanding that the procedural requirements under section 17.16 sub 3 have been met. The complainants, Peter Hans and Brian Utchik, are both resident taxpayers of the village. They have submitted written verified charges. The complaint was delivered to Mr. Hans by the village clerk on April 28, 2026. At that time, Mr. Imes Did I say Mr. Hans?
Yes.
I'm sorry, Mr. Imes. The complaint was hand delivered to Mr. Imes by the clerk on April 28, 2026. And at that time, Mr. Imes was provided written notice of the time and place of this hearing and informed that this would be no less than 10 days from the date of the notice. So those procedural requirements under 17.16 sub 3 have been fulfilled for this board to have this hearing. But there is one more requirement that needs to be addressed. And that is a fair and impartial hearing. So the respondent is entitled to a fair and impartial hearing. The governing authority on this issue is State Ex Rel DeLuca versus Common Council. In DeLuca, a municipal official argued that his removal hearing was unfair. Alderman who initiated the charges also participated in deciding the case. DeLuca's council requested disqualification of 4 of the 6 Common Council members on grounds of bias. The Wisconsin Supreme Court rejected that argument that officials are automatically disqualified simply because they helped initiate the proceedings. The court relied on a U.S. Supreme Court case, Withrow versus Larkin, where the U.S. Supreme Court put to rest the idea that an adjudicating board could in no case qualify as an independent decision maker in respect to merits of the charges that it initiated and investigated. The court explained that combining an investigative and adjudicative functions is not unconstitutional on its own, and that adjudicators are presumed to act with honesty and integrity. At the same time, the court emphasized that due process still requires an unbiased tribunal and that the adjudicators do not receive a blank check. The court stated that circumstances creating a high probability of bias, even absent proof of actual bias, may render the proceedings constitutionally unfair. And the court identified 2 scenarios that clearly reflected such high probability of actual bias as to be constitutionally intolerable. The first situation being where the adjudicator has a financial interest in the outcome, and the second where the adjudicator has been the target of personal abuse or criticism from the party before it. And the issue comes up in DeLuca regarding the submission of the charges as evidence of the alderman's predetermined outcome. The court again disagreed and stated the document's main purpose is to give notice of the specific grounds of inefficiency, neglect of duty, misconduct, or malfeasance. Such notice is essential for the protection of the individual's right to due process. But that document by itself is not evidentiary in nature, and it is not sworn testimony. I'm almost done. The court then turns to Lebo versus Optometry Examining Board to write, quote, "We conclude that Lebo correctly stated that a member of a board may initiate the charges himself and could subsequently make an investigation and sit on the adjudicatory board unless there was evidence to show that the adjudicators were so psychologically wedded to their complaints that they could not, on the basis of evidence, fairly decide the matter under consideration." So while the Lebo standard asks whether adjudicators were so psychologically wedded to their complaints, the objector cannot satisfy that standard merely by pointing to the adjudicator's role in initiating the charges. Rather, the objector must produce affirmative evidence demonstrating the facts specific to show that the adjudicator was so committed to a predetermined outcome that they could not fairly decide the matter on the basis of evidence. Ultimately, DeLuca holds that participation in Initiating charges does not alone establish unconstitutional bias. Rather, the inquiry is whether the facts and circumstances demonstrate the bias is of an unacceptable risk of unfairness. And the objector bears a heavy burden to overcome that presumption of impartiality and must show the facts created to make an intolerable risk of prejudgment unfairness. So that's the governing law on this matter. And I bring this up because I understand that the respondent would like to make a request.
Yes, I first would like to have an understanding of, at this point, if any board members are recusing themselves.
I plan not to, and I have a statement drafted accordingly.
So, yes, we would request the recusal of trustee Utschig and trustee Van Asten. We've made that request in writing. It has been denied. As trustee Lockby just explained, it is foundational in due process that you have an impartial decision maker. Here, one of the seated members of the board who will be voting on this petition is the complainant. And that's not all. We tendered to the board evidence of the statements that have been made by both trustee Van Asten and trustee Utschig, including trustee Utschig. John, you are grossly unfit to lead. You have no business in your role. You will not return to the work ahead. You'll resign. You'll be removed by your peers, removed or recalled. I don't know how much more direct evidence there could be to show that there has been a predisposition and a predetermination here as to trustee Utschig. As to trustee Van Asten, quote, I told you I would not vote you off the board. I have changed my mind and I want to tell you in person. Both statements, it's not even implied. They're saying you will be removed. I will remove you. So if there is any attempt to try to gloss over that and present themselves as or as impartial decision makers, I fail to see how that is even possible. Additionally, the original agenda for this matter that came out to the board, which was drafted by trustee Van Asten and trustee Utschig. In the original agenda, it was very clear that removal was a foregone conclusion. And that's because that original agenda prepared by both of those trustees indicated here's what would happen: a vote, an appointment of a new president, an appointment of a replacement trustee, committee assignment, and then substantive action.
Let her talk.
And it was only until recently that a new agenda was disseminated, eliminating all of those next steps. All the next steps that at least trustee Van Asten and trustee Van Utschig plan to take upon removal of the duly elected President Imes and said they would do. I think that these two trustees voting on this action, I understand the board is taking the position that they cannot vote to compel recusal. I disagree with that position, but I understand that's the position that the board has taken. It makes the ultimate decision that this board reaches so susceptible to legal challenge. I don't know why this board would take that risk. It would be a completely unneeded conflict, unneeded ground for appeal. I think everyone can appreciate instinctually that under due process, the decision maker about whether you did something wrong or did not should not be the same person who brought the complaint and said, I have changed my mind. I want to tell you in person, and you will not return to the work ahead. You'll be removed. These two trustees need to recuse themselves.
So may I speak now? So first, your reading of the agenda skipped the keyword. Oh, sorry. Your reading of the agenda skipped a keyword, which was possible. So the agenda had an agenda item on there that said possibly because depending upon whether John was to be removed or not, then I perceive that to be the normal course of business. It was not an assumption. So the first part, that's to that. To the second, or the first one that you raised actually, which is the comments, the email 6 months ago, where John refers to him leading us out of this with transparency. I responded emotionally to that, and I own that. But that was 6 months ago, and there's considerable evidence that has been presented that deserves a response. And I am not so biased that I cannot change my opinion given evidence. So genuinely, while I was upset in the moment then, and I said that then, that isn't how I feel today. If John has adequate answers to the charges today, I will not vote to remove him. Can I read my statement into the record?
Sure. Yep.
I've carefully reviewed the recusal request and the authority cited therein, including State, DeLuca, and Common Council, well, Franklin. I do not believe recusal is legally required under the circumstances presented here. I cited the cited correspondence, this was the one that she cited, opines that concerns expressed during prolonged and highly public dispute involving governance, disclosure practices, and access to information concerning village matters. Much of that correspondence occurred months before the hearing. Much of that occurred months before the hearing and before the evidentiary record was fully developed. While some statements were strongly worded, they do not establish that I'm unwilling or unable to fairly consider the evidence and arguments presented during these proceedings. Wisconsin law does not require that elected municipal officials acting in legislative or quasi-judicial capacity have to approach matters as blank slates, devoid of our prior knowledge, opinions, or public positions. Public officials routinely participate in proceedings involved in matters on which they have previously spoken, debated, investigated, and expressed concern. The relevant constitutional question is whether our prior opinion, not whether our prior opinions exist, but whether there is actual bias or such a constitutionally intolerable probability of unfairness that a hearing becomes impossible. That standard is not met here. I have no personal financial interest in the outcome of these proceedings, nor have I stated that I would refuse to consider contrary evidence, testimony, legal argument, or mitigating facts presented by President Imes and counsel. To the contrary, the purpose of the hearing is to receive evidence, permit response, and examination of witnesses, and allow the board to reach findings based upon complete evidentiary record. Strong disagreement, prior criticism, or participation in public controversy are not themselves disqualifying under Wisconsin law. The relevant question is whether the decision maker remains capable of considering evidence presented before making a final determination. I remain willing and able to do so here. Accordingly, I do not believe that recusal is warranted. I have a copy signed for you and a copy for the record as well. You wouldn't mind passing that?
May I ask a procedural question? Who will be presenting evidence on behalf of complainants?
I will begin. It'll
So
be me.
you will be also presenting evidence. You won't just be reviewing evidence, digesting it, and opining on it. You'll also be presenting it.
I will be presenting the
And
evidence.
you assembled that evidence?
I was one of two people that assembled the evidence.
Did you take time to also assemble exculpatory evidence or only inculpatory evidence?
No, I looked at everything.
Are you presenting exculpatory evidence today? Or only evidence to show that Mr. Imes is guilty of the things you say he's guilty?
So I looked at the events that happened and found the evidence that was there, read it and documented it. I did not find exculpatory evidence in these cases. And I do not believe, based on your response, that you did either. Now, well, for what I've read, now I might hear something today that says something different, but I didn't read it in your response.
So that's a no. You are here to present a case for removal.
I'm going to be presenting a case of what the facts are. Removal may be one of the possible results, but I'm only presenting the facts and a timeline.
If you could just raise your hand if you want to speak, I'll call on you. So having heard the law and having heard Attorney Dealey's arguments and having seen the evidence presented on recusal, are there any trustees who would like to recuse themselves at this time? Sure.
Also, for the record, Mr. Van Aston has not responded to our public records request, and he's the only trustee to have not, which I would just like the record to reflect.
Noted. Okay,
John did not respond to mine either,
Just-
and I would like to.
everybody, please wait to get called on. So that matter has been addressed. Are there any other pending matters before we start with opening statements? Seeing none, then I will ask the complainants to provide an opening statement. Try to limit it to 3 minutes.
So today's hearings are not about personalities, politics, or punishment. It's about whether the evidence presented establishes cause under Wisconsin law. Whether the board can responsibly make findings of fact based on the record it sees before it. As trustees, we each took an oath to act in the best interest of the village and to carry out our duties fairly, carefully, independently. And that obligation applies equally here. So I want to state clearly at the outset that I have not predetermined the outcome of this proceeding. And the purpose of this hearing is to receive evidence, hear testimony, and argument, and then evaluate it credibly and determine whether the facts support the charges presented under Wisconsin Statute 1713-2. This is not a criminal proceeding. The standard here is not proof beyond a reasonable doubt. The question is whether the evidence, taken as a whole, more likely than not, establishes conduct constituting cause for removal, including gross neglect of duty. Equally important, the respondent is entitled to due process, present evidence, to challenge allegations, and to be heard fully before any decisions are made. And that process matters, and the integrity of this board depends upon it. Public officials are not required to enter proceedings without prior knowledge of the issues before them. In local government, trustees routinely discuss, debate, and express concerns regarding matters later come before the board. And what matters is whether we remain capable of considering the evidence fairly and changing our views if the facts warrant it. And that is what we intend to do here. If the evidence does not support the allegation, that should be recognized plainly and openly. The evidence does support findings of gross, if it does support findings of gross neglect of duty or other statutory cause, then this board has an obligation to address that honestly and reasonably. The public deserves a process grounded in facts, fairness, and the rule of law, not assumptions about predetermined conclusions. Accordingly, I ask that all participants conduct themselves professionally and focus on the evidentiary record, which is what I will be presenting, so that the board can make careful findings of evidence here today based on facts.
Attorney Deely, you have the floor.
So there is one procedural point that I think I want to preserve for the record and just bring to the attention of the entire board, and that's the complaint is foundationally deficient. And that's because, as we explained in our answer, this board should not be entertaining a call for removal for anything other than what the statute allows under 17.13 sub 2, which is physical inability or gross neglect of duty. So in other words, where an official either cannot or will not perform the role they were elected for. I don't think this board has to undergo this hearing any more than it would if complainants filed a verified complaint saying that President Imes should be removed because he didn't wear a suit for a hearing. There is the statute cabins the grounds for removal for an elected body to remove one of their elected peers to those very specific and narrow grounds. The complaint doesn't allege President Imes has abandoned his post, only that they don't like the manner in which they filled it. And another reason that that's clear from the statute, and I explained the statutory analysis in our, request that the board just vote to dismiss this. I'll spare everyone that analysis because I assume the board has all read it. But additionally, there are removal statutes in Chapter 17 that allow for removal for reasons other than gross neglect of duty and physical inability. For example, the removal of state officials appointed and elected. The statute specifically says you can be removed for corrupt conduct or for criminal behavior. The village removal power does not say that. It says specifically gross neglect of duty and physical inability, and the two necessarily under rules of Wisconsin statutory interpretation have to be interpreted together. So nothing that has been alleged fits those two categories for removal. If there's any concern that Mr. Imes violated an ethics rule, he didn't, but if there is, it should be reported to the Ethics Commission. And if there's a concern that he violated a public records law, he didn't, there is a mandamus action. And if there is concern that he violated a statute, there is recourse through the district attorney in the court. And all of those processes guarantee the due process, including impartial arbiters, that the board does not have to do today. This complaint should be dismissed from the outset. Assuming the board continues to let the complainant put on his case, and I will say, most important, it's his burden to prove. I'm having a little bit of a confusion over the notion that it is the complainant's burden to prove his claim, and he's also saying he's not trying to prove anything. Those two things, they do not make sense. It's on him to prove that recusal or that removal is appropriate, and he's simultaneously saying he's not going to do that because he has no interest in the outcome. It's baloney. Anyways, if you're going to consider the merits and we're going to continue to do this hearing, I only request that procedurally, it's limited to what has been properly noticed. We have not received a witness list. We have not received a final exhibit list. We asked for more time for that to be able to happen so that we could review and test and mount a defense, just like you would see in any other sort of, proceeding, adjudicating alleged misconduct. And we were denied that work. And so we're going to be seeing this case at the same time as everyone else. And so my request of this tribunal is just that that court is very careful to only take evidence that has been properly noticed, especially given the request for additional time that was denied.
May I respond?
No. Okay, so we've got opening statements. The next item is presentation of evidence by the complainant.
Excuse me, was Peter gonna have an opening statement?
No, Brian gave it.
Oh, Brian gave it for both. I'm sorry.
So present your evidence, present your case.
Okay, I need to connect to the screen to cast. Is the best way to do that wirelessly or wired?
And join the Zoom meeting.
Oh, yeah, okay, that works. Thanks. Sorry, I should have thought of that. That's exactly what I need to do.
Recording in progress.
There we go. That's all right for everybody now that that's muted? Kate, is that right for you? Thumbs up? Okay, just making sure there's not reverb on that end too.
Speak in the microphone.
Oh, yeah, I'm sorry.
That microphone would be very helpful.
So, that being said, let me share my screen here.
Yes,
I gotta extend these permissions.
you.
Sorry. For crying out loud, yeah. Why does that look so tight? Put the city cast over.
There's a feedback here. That's why I can. So that may have to be turned off. That's what's going on. That's what it's called.
Did you share your full screen or?
Yeah, I thought I did. Let me try it again. This one. There we go. It cuts off the top though. No, it does, yeah. All right.
Please use an effective microphone.
This, does that work? I'm sorry, am I?
Now it is working.
Okay, yeah, I'm sorry. I'm gonna have to remember to lean forward. Normally, I don't have this problem. I was sick the last couple of days, so.
Do you want to try that one too? Maybe it just didn't work for me.
I feel like this one's better. Ooh.
No, not to, just pull that one
You
away.
got a feedback loop going there. You gotta either unplug that one and switch.
Now, is this better? Okay, it's better. I admit that that's better. All right. Just unplug this.
Your feedback loops, that's what's going on here. That's why it's cutting out.
All right. So I'm going to quickly go to PowerPoint here and why is this? Bear with me. There we go. All right. So consideration of gross neglect. Oh, this what's going on? Oh, there. Now it's back. This is a very touchy microphone. Yeah, that's gonna work real well. Turn my head sideways. Okay. Oh, there it goes again. So, the issue here is whether the total pattern shows a substantial failure to perform core duties, sharing material information, disclosing. Disclose. We're gonna go back to the other one.
Turn that one off.
Yeah, turn that one off.
All right, that'll be better. Not a little more awkward as I bend over, but it'll be better. So the issue is whether a total pattern shows a substantial failure to perform core duties, sharing material information, disclosing overlapping relationships, and preserving public records, and then protecting equal access to information. So in the end, the board can evaluate the totality of a pattern of conduct. So the legal standard, gross neglect does not require proof of, this is kind of, don't get this out of there, proof of a crime. The board is not acting as a criminal jury. The question is whether repeated conduct substantially failed core duties of the office. A pattern of conduct can establish gross neglect, even where no criminal statute has been charged. Next. There we go. So Attorney Dealey confirms that the village board has jurisdiction to determine if President Imes engaged in gross neglect of duty. She was in her written response to us. See from below the verified answer provided by Imes and his attorney dated the 11th of May, 2026. At the bottom, the only thing the board can decide here is whether President Imes is engaged in gross neglect of duty, Attorney Dealey. And this is, in fact, what the complaint alleged. It was talking about gross neglect of duty. I'm not sure how many people actually read the original complaint, but the original complaint structured things in a literary way, tying it into three themes. Those themes related to crime statutes. That was taken literally. But I thought it was clear in that gross neglect was the target in that. So the burden of persuasion. This is not beyond reasonable doubt. We're not trying.
I'm going to stop you for a second.
Yeah.
I'm going to ask that you try to stick with submitting evidence and facts and not arguments.
Okay. Gotcha. So prove beyond every possible explanation, and the board may evaluate conduct more likely than not, ponders the evidence, whether it was repeated, which is a big portion of getting gross neglect, and whether the totality substantially failed the duties of office. Also, that's going to be, I think, one of the key things to reach. So the theory, this is the argument.
These look like arguments to me. So just go to evidence.
Oh.
Do you have evidence?
Yeah. So
Okay.
we'll start charge A. Logic's financial information. What was requested, what was received, what was said publicly, what was later denied. So to start this whole thing off, charge A was centered around the Logic's acquisition. Okay. First, President.
Would the complainant be willing to identify in the already disclosed material what he's referencing and confirm?
So it says that on the bottom. It's hard to see up there, admittedly. You know what? May I pass these out? This is printed and it's referenced on these printed versions. May I hand these out to everybody else here, just in case it's easier to follow along? Is that permitted?
Yeah, Pez shop,
Yeah, I know.
Okay.
Sorry, I only brought enough for up here, everybody. But the citation is on the bottom. And this was actually included in your exhibit 1 in John's response to us in his affidavit. So President Imes asked for a summary event of the revenue that he can share before the town hall on September 2nd. So it says, ask her to pull at least a summary of event revenue that we can share. The town hall follow at 7 p.m. So this is just taken from that email John asking. Ava Kenny says, here's a financial document that may help. Sent to President Imes' personal Gmail before September 4th, town hall. So there it is right here. John Imes other. Oh, sorry, this is the second part right here. Ava Kenny sends it to John. Now, interestingly, John's Shorewood Hills Gov address is included. I will say that Open Records Requests did not return this request when it was requested. So this was a surprise to me to see John's email address there. But here is a financial document that may help, she says. Now, what was that? So in that town hall, some of you may remember, John says at 1 minute 37, revenues were as high as $393,000 per month. That's taken directly from that document. Only quoting top line. There's no curiosity about profitability. No mention of the fact that EBIT is sitting there in parentheses, which means it's negative, right? P&L chart. October revenue, he cites. That's from there. The January revenue figure shown in the P&L, $234,500. Not only you'll see in the video here, but January and that. This isn't a specific round point. It's just a specific spreadsheet number. He also says they had good cash flow. The P&L reflected but good cash flow. The P&L reflected a 6 month that he was sent right there. This is actually a copy of it. It reported a loss of $500,000 in the 6 months. And I'd like you guys to watch this video to understand what I'm talking about. And oh, no, the audio's not going to work.
You turn off your mic while it's playing.
Good thinking. Let me see if I can select a different audio. Sorry, everybody. Should have come and practiced this in advance. More share computer sound, stereo high fidelity.
You have any teenagers in the room?
Taylor.
On Zoom. You shut the mic.
Taylor's giving you some advice.
You have it saved somewhere else and. Maybe better.
Here.
And Taylor,
Let me see if I can do.
Taylor, if I send you this video, well, I'm not sure how I get it to you at this point. Taylor, actually, can, wow.
So I don't know if we can play. If you mute your computer, you are not going to be able to play the audio without any sort of feedback loop.
It's the whole big mess. Online.
Hmm.
Hey guys, I think if you play it through Zoom, Brian, so if you go to the caret next to audio and you turn the volume down on your computer and you select and you play it through Zoom, everyone online will be able to hear and the room may be able to hear. It's as if you're unmuting a participant on Zoom to speak.
It tells me I'm unable to start video when I try that.
Got it. Okay.
So what I can do is I can, well, when we come back to this, I will can proceed. But this video is in my thing and I can circulate it afterwards, including sharing the transcript of it. But those are direct quotes taken from it. It's inside of a 2-minute window. A lot of you will remember.
Can we
it.
mute this for a second while you play it?
I don't think Kate will be able to hear it if we do.
Well, that might be the feedback source.
Yeah, let me try picking up the microphone. So. That's enough, I think. I'm gonna return this on. Okay, does that work? Nope. Now does it work? No. No, well, all right, sorry about that, everybody. It's my first time ever doing this on this thing, presenting like this. All right. So just, I don't need to recap that, so I'll just move on. I did hop over to the thing, just go back to the PowerPoint. Yeah. All right. So on November 7th, now this is all the way out in November now. Remember, that video was September 4th when John got that and made those statements, right? In the interim, the comments and the other stuff that was referenced earlier, where some of us noticed that there were numbers that were missing, we were aware there was financial documents, and we were aware of the fact that Carol, and because it was said up here, that Carol, Dietmar, Shabnam, and Kate were not given those documents, right? They weren't shared with them, so they were withheld from them. So November 7th, because we're looking at buying a building and operating two of those businesses are designed, they're laid out to be a daycare and a restaurant. The P&L does matter. And Shabnam got the P&L directly from the seller. So this is Tim Rickers, who was with Cressa, also a resident, sending this over to her. So the record site, it's not something we could have shared, and Brian has had that. I've had that. So John didn't deny having the record or the P&L. Now, this is a later statement, all the way up November 23 to me. Okay, Brian, I'm writing because of the accusations in your message are extremely serious, factually incorrect, and harmful to individuals in the functioning of village government. And I want to respond directly, clearly, and respectfully, so there's no confusion. First, that staff or I withheld the logic P&L or other information is unequivocally false. This has been said repeatedly. I have never received the detailed logic P&L document. So in Attorney Dealey's answer that she sent to us, it said, the information President Imes received was a generalized profit and loss statement that wasn't comprehensive, less as comprehensive as the information Trustee Lofty received a month later. So the detailed profit and loss statement that John received in September, let's go take a look at that. Here's what he received. So this, when you hit the here document, the here that was in that first email from, oh, sorry, I got to share my whole screen. Make this work. Desktop line. Sure. Now this is gonna be hard for you guys to read. Okay. But what I want to show is that these values, it's not going to let me zoom. Come here. So Clever Moose, revenue, field and sales, cost of sales, cost of food, cost of beer and wine, kids camp, tuition, meals, total revenue, benefits, workplace revenue, dedicated desks, labor. This is the full P&L version. The difference between those two documents is that the P&L statements received by Trustee Lofty and Imes were materially the same, and they showed significant losses. The P&L report secured by Trustee Lofty only was just, it showed a full year of operations. It showed May 22nd through April 23rd, with a $522,000 loss for the 6-month period, May to October 2022. The P&L President Imes received on September 4th for May, October, it shows a $500,000 loss for the same 6 months. So both P&Ls show the building losing money. And the document that I just showed you is like, that's directly, if you click the here link that was provided in that Ava Kenny link, and it's in my supplemental information that John was served. When he was served, I gave him 168 pages of evidence to be able to respond to the day he was served. And the P&L shows the building losing money. The only difference with how many months were reported. So in the affidavit by President Imes on the 11th of May, two statements relevant to charge A were made, which are examined below. Statement 1, I am not an expert in reviewing these types of reports. On page 8 of Exhibit 2 is a chart showing the revenue for May, October 2022. When I saw that revenue was near or above 300,000, in my opinion, that seemed that Logic was doing pretty well and was pretty successful. President Imes. President Imes neglected his duty when he didn't share that P&L statement with the other board members or qualified experts, given his own admission that he's not an expert in those types of reports. You know, for example, Kate as an MBA, there's Dietmar was on the board at the time. This is not a statement 2. Regardless of my observation and comment, Logic's overall operational success did not seem relevant to the potential acquisition because the village was considering purchasing the Logic property, not the business. And my understanding was that the village would not use the Logic property in the same way. So the profitability of the business model didn't seem relevant. Well, he neglected his duty when he didn't share that P&L statement I forward here because what would have allowed him to make his own determination on the relevancy of the information, the board members needed to see that. That was a restaurant. It was being bought with equipment. Restaurant equipment was all included in it, the hoods, the ovens, the refrigerators. That was extremely expensive to remodel. If we weren't going to buy that operate as a restaurant right away, there was no budget in there for capitally remodeling that space in that acquisition. So it needed to be able to show that it could run and be profitable as a restaurant. And the same thing is true with the shared daycare facility, which is also built out as a daycare facility with playgrounds and the whole nine. There wasn't a big remodel budget in there for that space. The idea was we were going to open a daycare and a restaurant, and we were going to sit between them, right? That was the idea. So that's the end of charge A surrounding Logic. Now, conflict, charge B. So I just want to, before I go on, we have a duty as trustees to share information with each other to meet our fiduciary responsibilities and our legal obligations. We need to be able to trust that happens in order to be able to govern effectively, to be able to make decisions. That information has to make it to all trustees. Conflict, disclosures, concerns. Relationship, village action, participation, no recusal reflected, contrast. So for each example, the record shows will follow 4 steps. Now, this is an argument, so maybe I should skip this, but it is important for the thing. WUI's relationship of supporter overlap, village action involving the same related entity, John participating in the action with no record of disclosure or recusal in the record. So records show that, sorry, that's my John and Mass and Gas and Electric, WEI was within the governance. So if you look here in the board of directors, you can see Boardman Clark, excuse me, and you can see the Mass and Gas and Electric. And this is true of many years inside of John's annual reports. Support and partners. Again, you can see Boardman and Clark, Stonehouse Development, Madison, and Glasgow, and Boardman and Clark. So these are the 3 that I focused upon in this. So, and here's an example of an MG&E easement that was being asked for. So here's Village President John Imes, and here is someone from MG&E, along with someone from Vanderwall. And here's the motion to approve the easement. In this case, Dietmar, I got this wrong. But this easement was approved and the motion carried. So in this, here's John. There's no mention of recusal, no mention of disclosure in the meeting minutes whatsoever. So here's another one. The shared solar program that was just went on, right? And this actually helped in 23 as well. Discussion, possible action, MG&E shared solar program. MG&E shared solar program, see memo from village president in packet. Now, if you all recall from the meeting minutes or from attending, In this particular case, it skipped the committee and John brought it directly because of the urgency of bringing it to us. They thought that they might go away. So he presented this shared solar program to us, right? No mention of disclosure, no mention of recusal. Board retreat with the labor attorney for a policy for a management discussion. So in this case, Boardman and Clark the minutes show that President Imes called the meeting to order, approved the hiring of Boardman and Clark for a board retreat, and the motion carried. Boardman and Clark, payment of bills. Again, motion carries 6-0. All he has to do is mention or recuse for these things. They're not. So that this is WI support overlap. Again, Stone House Development is also appearing repeatedly in multiple years as a contributor. Here is an ordinance recital. Stone House Development, Inc. is the applicant in January 2022. The record shows Trustee Basooner recused himself. The T amendment was discussed. Additional TIF support was discussed. The original tax incentive agreement passed in 2022 with an amendment in 2023. And the record shows that Trustee Basooner again recused himself. So there was even an example of conflict being discussed and raised. President Imes moved for approval. The motion carried 6-0. Trustee Basooner returned afterwards for that. So this is, again, all of this is contained in these 168 pages. Should we give this to Taylor? Do you want to put this in the record? How does that work? Oh, sorry. Can I give this to you to put in the record?
You have to put it in the record. So
I should put this in the record. This was sent to John when he was served, and then it was digitally sent. But that should definitely get put in the record. And then I have a digital copy of this that Taylor already has. Can you please put this in the record as well? Taylor, the PowerPoint presentation? Okay. Sorry, I should have done that in the beginning. So, the Ella Apartments, Greenbelt certification. WEI was provided Greenbelt certification services to Stonehouse Development, opened in 2022, called the Ella. And it can be seen in images from the WEI and the Ella websites. So here it is at his website. Here it is cutting for the Ella Apartments, a new landmark affordable housing community, Wisconsin Greenbelt certified.
I would object to this line of evidence. It wasn't in previously disclosed material.
I'm not sure that's true.
Well, if that is the case, then we would omit it. Well, it's related to the charge. It's not outside the scope of what we're discussing. So I will allow it because it is related to the charge.
Okay.
Could you just wait 1 second?
Yeah.
Is that a correct decision?
Well, I can't state whether it's a correct decision, but an objection is noted. It's of the record, and the board can certainly receive the evidence.
Okay.
If that being the case, it will be submitted in this document, and the website is literally listed in the document here. So this is just publicly available information. And then here's John at a cutting ceremony at the Ella with the folks from Stonehouse as well at the same time. So the affidavit that we were presented on May 11th we had two statements relevant to Charge B, which were examined below. Statement number 1, Madison Gas and Electric has not contributed to WEI since 2019, and Boardman and Clark has not contributed to WEI since 2017. President Imes. President Imes does not address the influence that Boardman and Clark or MG&E would reasonably have over his employment or compensation as the sole employee of or as the board of directors, at his position at WEI. Nor is it required that be the only thing of value to be exchanged be money. Certainly their guidance, counsel, and serving on his board has value. 2, WEI does not have any current financial relationships with Stonehouse, Boardman and Clark LLP, Madison Gas and Electric, or Renew the Blue Council. President Imes only comments on current relationships but not past financial relationships that might align with board action, such as overlapping timelines between WEI work on Stone House and LO Apartments, and the village approvals for the TIF and the zoning for Stone House project at 2725 Market Court. They all line up neatly in 2022. You look at the voting record. So charge B, pattern for the board to evaluate. WEI annual reports show overlap with MGE, Orban and Clark, and Stone House. Village records show actions involving those entities or related redevelopment matters. The minutes contain recusal language for trustee Basuner for the Stone House and the Tiga matter. And the same records do not reflect a comparable disclosure or recusal by IAMS in the cited examples. So, and this is included in what was presented to you, even though it says it has addition here, but renew the blue. So just on October 6th, 2025, the council, the Renew the Blue Council, had 20 organizations and had already listed the village of Shorewood Hills among the organizations that had joined us. This is Renew the Blue Council members. It's midsummer update progress. These organizations have joined us, Village of Shorewood Hills. This is long before the August 19th board meeting where the approval was later requested. Renew the Blue Council, as of 7/30/27, the Capital Area Regional Planning Commission, Village of Shorewood Hills listed. So again, this list states Renew the Blue Council as of 7/30/2025, and this includes the Village of Shorewood Hills. Packet says, if the board agrees to join and proposes a motion authorizing the village president to sign a membership agreement. Now, don't get me wrong, Renew the Blue seems like a good organization. It's not about the organization or shared solar. Those are things that I agree with. But this is about disclosure and transparency. So President Imes encouraged approval and was designated as a representative in the minutes. So he was encouraged the passage. The motion was authorized. Imes and Mooney were designated representatives, and the motion carried. This is what's reflected in the minutes. So the council says Shorewood Hills, 7/30, I'll use July 30. August 6th, Clean Lakes emails, you have joined us. 8/19, board packet says if the board agrees to join. 19, the minutes encourage approval, and that's when the vote happens. So the board can decide whether or not that was properly disclosed. All right. So those are the conflict of interests. Again, the theme here is being able to trust when we go into talking about developing other properties, flat garden homes, the stuff that all the land is still village hall. We need to be able to trust and exchange information as a board. In order to make the big decisions that are ahead of us, we need to be able to have those kinds of conversations. Charge C, records and communication practices. So the C narrative, okay, this is not another P&L argument. So this is a change. This is a records and a communication practice argument. So some of the information from the P&L is in here as an example, but it's in as an example for a different reason. So it's about OR, open records handling, that's ORR by the record, open records requests, MailChimp and personal accounts, as well as unequal access to village material. So the change shows village-related materials in President Imes' personal Gmail and forward with instructions to print in response to an open records request. Personal account communication, part of the public records issue. So this is the Ava Kenny email that was being forwarded to Kate here. And printing it would have made the links not work. John, please send the few sheets of financial data from the building manager to this group. Not in the working Dropbox link, nor were there any provided residents to respond to record requests. If they were in your emails, they should have surfaced. So when a resident asked for a few sheets of financial data that had been shared, nothing noting they were not in the working Dropbox, they weren't produced in any ORR responses. So the records issue is tied to material information, who was stored, who could access it. Again, if we're going to make decisions as a body, the body has to have the same information. Unequal access becomes the core governance issue here. So still do not have the spreadsheets Bob and Mark had and the Dropbox today. Anything else is selective disclosure. So this is Shabnam on the 30th saying like, hey, in the meetings about logic, we were presented information. The information we were presented had a bunch of financial information in it. You said you would share that. Still have not been presented it. And we know that Bob and Mark had it because they did the logic of logic and you had already conceded that they had it at that point. Gloria Beach or our WI MailChimp. So I would like to open a public mail records request for all recipients and corresponding email names for the WI MailChimp because John was using his MailChimp to reach people and trying to build support for buying a logic building. And he was using his campaign email, his personal email, not a village email address to do so. So he's using a private mail list and not sharing to whom he had reached or who he was omitting, which made it very difficult to look at that. So resident requested it, MailChimp was used, and sender address was not, we had the sender address from MailChimp, but this was never answered. So using mass email programs such as MailChimp, so this was, according Computer Magic noted that sending messages in large things that this can cause delivery failures with things like MailChimp. And the village doesn't possess or have access to those. And that public records law does not require them to provide records they do not have. So, but the village didn't possess it. And so John was asked for it directly. And then DA request, provide or first keywords for entities, email communications. So all communications from the below government email accounts, this is from the DA's request specifically targeting John's email addresses that were noted in meeting minutes, John Imes other. And then you'll notice this, there is one that was on here that is a weird MRPS 15. I will say, you asked if I found any exculpatory evidence before. I believe that's not John, by the way. That is totally, that's a spam email address. In future things, that was added in there. Somebody else was using the wrong email trying to reach John. So that should actually be struck. That actually is not true. So, so the DA request, the entity includes Stonehouse and development entities. So here is this is the DA's request, by the way. So the same DA request is also listed Stonehouse and development entities as requested records inside of the scope. So the board isn't being asked to evaluate.
Argument.
Oh, yeah, that's true. Okay.
Sustained.
Yep, that will be the end of the thing. So this is the rest of it is argument. So I'll stop sharing. Those are the three pillars, and that's the evidence to support it, broken down through the 168 pages of binders, itemized in detail in the PowerPoint presentation. And Taylor, if that's uploaded to the link, residents would be able to look at that themselves to be able to verify the fact that it's all true. Or to determine, I mean, I found all of it there, so I would presume it is, but we'll see what they have to say here. I'll stop sharing.
Mr. Epchick, are you finished?
That is the end of the evidence presentation.
Attorney, would you like an opportunity to address any of the evidence that he has submitted?
Yes. We get an opportunity to ask him questions about the evidence he's just submitted.
1 second. Did she get to ask the committee? Sure, go for it.
Why not a recall?
Well, a recall has a predetermined thing, right? Even when I was upset with John in the email that you cited, thinking that I was biased, I was upset about the fact that I wasn't getting answers to the questions that I just showed you the evidence that I saw. I suspected that P&L data was there before it was confirmed, right? And I was upset about it. Recall doesn't give John a chance to respond. It doesn't, there's no evidence. Nobody would find out about, or there's no hearing where evidence is brought up, discussed. John has a chance to respond for the record. We just have he said, she said in terms of the village body.
Then that what an election is?
Well, there's power.
Objection relevance.
So
What I'm saying is the opportunity presented is to address the evidence. It's not an argument about why we're here. If you would like to address any of the evidence, this is your opportunity to do that.
So you're not gonna let me ask him why he's decided to do this instead of just present the proof? If that's the answer, okay, then we don't have to get into it, but
I would kind of like to answer it. So
I'm going to request that we follow the process, which is you have an opportunity to address the evidence.
I have an opportunity to cross-examine the witnesses that are brought against the client and to identify bias.
You know, I think that that would be an opportunity when we switch spots and it's your turn to present. Would that be allowed? Would that be okay? If you would like to examine the witness, could we do it then?
No, the statute allows me to cross-examine the complainant. That is foundational due process.
I don't disagree with you. I was just saying the order of operations, that you would have that opportunity. The order of operations at this moment is just to address the evidence.
I think this is
Okay.
addressing the evidence.
Well, go for it.
So you didn't want to present all of this to the voters for them to vote. You wanted to do it by a removal procedure.
So just like in federal politics, there are purposes for recall elections versus the equivalency of like an impeachment or something like that, as we'll call it. One is for a policy disagreement. I would say recall is appropriate there. Here, the question is misconduct. In that regard, I believe that because of the level of detail required to follow all, especially for the electorate, the village body, that whether it's possible that this hearing ends in a recall. Like that is not outside the normal possibility. But if we didn't have this hearing, the evidence wouldn't be put in a place where everyone had equal access to it and where it was responded to openly. So, so to answer your question, why not a recall? Because we needed to have a hearing to get to the bottom of when it was done and how it was done and all come to agreements whether this was mishandled or not, instead of a he said, she said.
Okay, so going through your different buckets, you have 3 different buckets. You say warrant removal. Right?
Yes.
Because you do agree, it's your opinion that they warrant removal.
So to be fair, I believe that all 3 of them raise questions about whether gross misconduct is as a sustainable charge, right? So in A, the not
You
sure.
haven't predetermined anything.
So honestly, if there is evidence that comes back that shows that the information that's presented to you there, like the John Zyme other email, is incorrect, I will switch on a dime.
Okay, so September 2nd, I'm on, your slides are not numbered, but September 2nd, John asks for a summary email from a representative of Logic, right?
Yeah, from the seller, Cressa, the real estate agent, yes.
And that was Ava, correct?
Yes.
And then on September 3rd, a linked document is provided.
This is correct.
And that is the same document that you provided in the stack of 168 pages. In your stack of exhibits, correct?
Yes, if you'd like, I can show you. When you go and open that document, it pulls up the document that I showed you there. That is the one that is, when you click that link, that is what opens.
Sure. So I just clicked the link.
Mhm.
I'm happy to share my screen if that's how folks would like me to do this,
Hit-
or I think you have,
Hit download.
if you want to share your screen, I can.
Actually, you can go ahead and do so. It's fine. Just trying to zoom and do it. But you'll need to hit download, and then the file you get is the one that I showed.
Do I have to join this Zoom too?
Yes.
Oh, yeah. You have the email. I think you pulled it up, right? You could click on the link here.
I did. Let me just find it. Because I'm gonna need the working link that's not printed.
Whatever you need to make this go smoother.
Sure. Well, I think the easiest way to get to that document is it's in your exhibits. It's exhibit 1.
Yeah. I just don't, I can pull it up. I think I just have to join the Zoom.
Well, could we, everyone who's presenting evidence, could copies, electronic copies of anything that you've displayed, can they be provided to Mr. Wall? And there is a OneDrive that can be utilized by the members who are online. In addition, it will act as a place where all the exhibits will be kept, and perhaps then the village clerk could display documents as requested.
I have already emailed all documents to.
If it would make things less painful, that could be a good idea. Maybe take a 5-minute pause, upload exhibits, and then bada bing, bada boom. Lots of things are moving forward. Does that sound agreeable?
Sure. We can take a 5-minute break.
I have no objection.
All right, vote. That was fun. Oh, you're getting sure, we'll pick that for after. Thank you. Tyler, right? Taylor, sorry. So I need to upload straight into the OneDrive.
Okay, I can do this. I worry. Like.
You need it.
Thank you.
Was I provided this much before?
It's
Okay, so I didn't like get the direct.
You sent me this downloaded file. It just says-
Exhibit 1?
Yeah, but I don't know if the.
Oh, you just said it a second ago. Never mind.
Yeah.
Do you have a copy of the spreadsheet? I'm not sure.
Actually,
So.
but I want to.
Oh.
I just want to.
Oh, yeah, they are.
How do I break this thing out?
It is. There's a little bit of. Okay, it's working.
I should get a gavel. I do not have a gavel, and I am trying to project. We're gonna get started.
Can't do much.
Okay, we're ready to get started. Attorney Dealy, the floor is yours.
Okay. Mr. Wall? If you could pull, combined exhibits from the complainant, page 7. Just to back up, as I understand it, you say that there was some document that John got on September 2nd that contained detailed profit and loss information. And it specifically indicated on that record that he had on September 2nd, you circled the number 502,000.
I did,
That was lost over 6 months.
yes,
And in your combined documents, you shared that record as well as exhibit 2, correct?
yes.
Okay, so that's page 7.
Actually, I may have shared the reduced PDF version of it there.
Well, page exhibit 2 is intended to represent the linked document that John had received, right?
I would need to check myself, honestly. I'm sorry. I gave my copy to be scanned into the record. So, yeah, exhibit 2.
And so that's the document that's presently on the screen, right?
Yeah, there was multiple pages of it, I guess.
Yes, if we could go through now, is that the second page or what page is that?
This is the first page of the spreadsheet.
Okay, can we go to the second page? Okay, this is the second page that John received on September 2nd.
Does the printout must have gotten cut off and the thing that I showed you.
Madam, or can you hear okay?
Yeah.
Sorry,
That's okay.
Yes. Okay, so that's the second page.
I actually would need to, I can't read the things. It's so small if you want the honest truth. Don't have bifocals with me.
If you could lean towards the mic,
Oh,
at least.
I actually am having a hard time reading it, to be honest, because the print is small.
Well, turn to the
So-
first page.
Yeah, I see it.
So exhibit 2 was offered by you as
Yeah.
the document that John had linked in the September 2nd email.
Net income, yes.
Okay, so I'm not gonna get into the minutia of the numbers, so you can spare your eyes.
Okay, this is a million and something or other there.
So page 1, we're on page 2, correct, Mr. Wall?
Yeah, we are.
And can you go to page 3? Okay, and then please page 4. Page 5. Please keep going. Page 6. And if, Mr. Wall, can you please pull up 2 email? That's what the file is. That is exhibit 1 of our answer. Can you pull up the email?
Yes.
And so this is the email where John received the detailed
Yes,
profit and loss. Okay,
cool. Does that have a link on it?
yes.
So,
Mr. Wall, could you click on here?
yep.
You
Okay,
know, this is no fun for the.
no. And now if you just look at this document, it's just presenting it online. You have to hit the download button. This is the profit and loss statement from the seller.
You could go down.
Click download, please, and then download that document, just to show everybody. And then open that, please. Download above, right there, up top, next, under sign in. Thank you. And this backup update document is the one that we later saw reflected that Brian shared as the,
Mr. Wall, could you stay on the browser version?
You betcha.
Because this is the version that's accessible if someone were to like open it from there. If you could go down to the next page. And the next page. And the next page. You can keep on scrolling down. Right. You can keep. It doesn't appear to be, I'm not trying to be cute. It doesn't appear to be the same document.
so, I mean, click download, it is, I'm not responsible for their rendering, but imagine you are sent a document buying a $7 million building and you have a fiduciary responsibility to go through it. Are you telling me that you're gonna download it? Like, download it.
Do you know if, do you? Thank you
Hold on.
for the patronizing responsive question, but,
I mean,
do you know if John downloaded it or if he viewed it like on his tablet or his phone?
I have no idea. There's a chance to answer that here, right? And then, and if he never looked at it, right? If he never downloaded it from the seller and looked at the P&L information, that is a comment that he can make on the record. That's totally fine. If that's the defense offer is that he didn't download the P&L
Hold
from
on.
the seller.
Can I clarify?
Sure.
Okay. This is the link to the September 3rd P&L. The P&L in Exhibit 1 of Trustee Uchik's documents is the P&L that I received in October. That is the difference between these two.
Okay, so in the exhibits offered by the complainant, the document that Mr. Imes received is not in that offering.
I did not see that document in the 168 pages.
Okay, so when Mr. Imes, when you say the document that Mr. Imes received showed the loss figures that you're interpreting, you haven't actually offered that document that Mr. Imes had.
So to be fair, I will concede, looking at this, that the one that's in here, I'm gonna flip through here, because I did put one in here. That was one of the printouts that came from Ava Kenny, and that's at the bottom of that email that he just had up a second ago, because there's 3 attached Excel
Speak up,
spreadsheets.
please.
I'm sorry. So in the email from Ava Kenny, there was that link. And there was also another email from Ava Kenny that you actually responded with in your exhibits as well. And that one had a number of other links, including 3 Excel spreadsheets.
One about your complaint
Yeah,
and what you brought for the board's consideration, and that was the linked document that was sent September 3rd. But that document is not in the offering that you made in terms of evidence.
it appears that the one that is printed here is not the right one. But I do cite the right one, and it's shown in the email with the Ava Kenny with the link saying here. And it's all quite delineated, and we can download it right now and add that into evidence. In fact, Taylor, can you download that document and make sure that it's added into evidence? I'm sorry that I did not catch that mistake. I'm not an attorney. I did this all in my limited free time. That was not intentional by any means.
Well, it should download whatever on here link.
Whose exhibit is this?
But, good question. That's gonna be my exhibit. It's to replace exhibit 3.
Well,
I would not replace an exhibit.
no, we're not replacing it.
Okay.
And we can do these sequentially. So we can have, and this is my understanding, exhibit 1 is your PowerPoint.
Okay.
Exhibit 2 is appendix A to your complaint.
Okay.
And exhibit 3 is it the document that's shown on the browser view?
Yes.
What about my statement about recusal? That should be one of the exhibits too, right?
That's on an evidentiary exhibit.
Okay, I wasn't sure.
And then exhibit 4 will be the downloaded version of the profit and loss statement.
The screenshot version, was that a number?
3.
Thank you.
I will need to find out how to get that web browser situation in as an exhibit.
Might have to take screenshots.
Yeah,
Yeah.
after, and we can all look at it and agree that it accurately represents.
Okay. All right.
And then, exhibit. No, I've only cited the things we've already approved, so. I guess we'll call exhibit 5. Procedurally, we've labeled our exhibits and attached them. How do you want those to align with the hearing exhibits? Oh,
We can relabel them.
so then. Ooh, gosh. So, declaration exhibit 1 will be hearing exhibit 5. Is that right?
It's that same email, right?
Yes.
Yeah.
It can, and if you would, Mr. Wall, please download.
So I did download this
Thank you.
spreadsheet. I need to upload it now.
And the difference, if you, it's your time to talk. I'm sorry, I was gonna explain the difference.
I'm sorry, I can't hear you at all. Thank you.
Never mind, it's her turn to present evidence. I shouldn't be talking. I forget about the trial nature of this. I've never done anything like it. This is.
Okay, so accepting exhibit 3, which I will have to screenshot later, everything's on the one.
And if you could pull up exhibit 4. Thank you. And buckle up because this is going to be boring. But it's important because this record wasn't in the evidence produced. And so you went over before a bunch of slides showing out all the things that John should have noticed and flagged for everybody. But so I need you to point out on this document, where is the loss statement that Mr. Imes should have pointed out, and for failing to point out, the board should vote him out of office.
So scroll down. There you go. Now, you'll notice, John was curious about revenue, right?
No, I'm just asking you to point out
Sorry,
the
keep going to
number.
the left. You scroll aside. No, sorry, you have, yeah, you go either. Stop.
Right.
Sorry, go back actually, because what we're looking at is, so they had their estimates in here, so just bear with me. Well, I'll actually just look in my presentation, but it'll help me find it for you. Because that one shows $1 million loss.
Well, the screenshots.
Yeah, that's what I saw.
The screenshots in your presentation, I understand, were derived from your stack of exhibits, and we've already established that your stack of exhibits doesn't actually include the document that John reviewed in advance of the hearing. So your screenshots on your PowerPoint are irrelevant.
Well, respectfully, the ones on the charge A, the ones about the figures that he quoted in the live town hall, those were actually taken from the online version, the one that you saw, those numbers that he's quoting out loud.
Well, that
So
calls
those,
into question all of your evidence here, because each page you include the source by page number from the evidence you can use.
it's in both of them.
Oh, we'll just take your word for it.
You
Okay.
know, you go ahead and click on it. It's there. It's on your board presentation, I think, it's the graph version of it, if I remember right. So those are the graphed numbers that you saw print out oddly in the end. See the numbers up top there? Those are the ones that are turned into the PDF.
Yes, that is from what is now hearing exhibit 5 that we produced.
Yeah, I mean, it's just when you pull up that website, it opened up this tab instead of the other tab. But they're just tabs on a spreadsheet that were both there.
Just to clarify, we're looking at the document Mr. Imes received on September 2nd.
Yeah.
Okay.
Well, that's what's reflected here too.
Yes, and that's the document we presented. It is hearing exhibit 3 and 4, correct?
Right.
It is nowhere in the material you produced.
Yeah, I mean, I also provided the Ava Kenny email as part of evidence that had the link to say here. I mean, it's in there. It's just, I printed the wrong one in the binder, but it's clearly pointed out.
And so these numbers that you go over in your PowerPoint, those are screenshots from your combined final exhibits, correct?
These are taken directly from the document.
Okay, so where it says I'm supposed to go to pages in your binder, that's not correct.
That's referencing the point and not the picture. You're correct. That's referencing the point and not the picture. So,
So if we can go to the page in your spreadsheet where it says P&L chart, October revenue, 393,500. It's on his PowerPoint.
yeah, 393, yep. So this is 393, 3,000. is from,
Can we hold until the document is being displayed
oh, sorry.
for the member who is appearing remotely?
And I'm not trying to be difficult here. I just want to understand where these numbers that you're referencing come from.
Yep.
Okay,
And I'm sorry, which page is it in the spreadsheet, or excuse me, PowerPoint?
That is on page.
Around
I didn't
11.
number it.
page 10 on the power.
So,
So that screenshot is from here in exhibit 4.
I can't remember which one exhibit 4 is, but yeah, it's from the power. It's from this Ava Kenny's email. It's literally like that number's right there. It's actually on the top of her thing if you look at it.
And then if you go to page 11, that number, revenue figure 234.
It's on the next page of that printout, yes. And under the board presentation or the one that you see up front, that's on tab 2 that pulls up when you open up, when it has the preview of what's in the document.
And then the next page, well, where you circle this 502957. And you offered this as the,
Yeah, but shows them side by side. So I keep in mind, when I built this, I was putting this together to put all these spreadsheets together. And I pulled these two to be able to show how similar they were. Because the difference between the two of them was only that the first one included projection data, the one John saw for the second half of the year. And the one that Shabnan got had the actual data filled in. So the difference in those two, and this is why John's numbers that he cited where the revenue looked good is 393, 500 and to whatever it was, 34, 500. Those were, I mean, revenue numbers almost never end in 00 or 000, right? A P&L. So those were the projection numbers. Those were so that's why they look that way. And if you look at if you actually look at the document, when you have time to go look at it, and we're not all here, you'll see that that is true. The document says, this is literally the projection for the year that they did then. And it's got the numbers that match up until the date. And then they put their forward full revenue numbers in.
so he mistook projections as actual revenue figures.
I believe that to be true. Yes.
Okay. Do you think during the next break, you could look at here in exhibit 4 and point out
Totally.
what you think was the number that he should have noted as demonstrating the loss?
So I can show you right now, just on the first one. Can you go back to the one that just Ava Kenny sent, just the email, when you just click here and it opens up to the bad copy? I mean, it literally shows EBITDA, right? And it says it's in parentheses. Parentheses are a negative number. Revenue is not the measure that we measure successful business by. We measure it by profitability, right?
Mr. Wall, could you pull up here in exhibit 3? Thank you.
What is the
That's
file?
the gear link. That's
Okay.
the Gmail. Link. This is gonna be the most horrendous of our record. My apologies. And what I need to say that is really hard. I'm sure everyone feels the same way. Okay, now, can you point out the loss number that Mr. Imes should have noted and should be
Yeah,
removed?
just scroll
for not
to
noting?
again, scroll to the bottom. So we're at the end here, right? Nope. Oh, yeah, gotta just say that. So it should, no, I'm sorry, not to the very end of the document, just to the end of that spreadsheet thing. Right. This is their projection number still.
You need this spreadsheet.
I don't, without looking, I need the actual spreadsheet. Hold on. I'm gonna need to share my screen in order to do this. 'Cause this-
No,
Can I be of assistance here? In the downloaded version of the document, which is, you have a circled number of 500,000. Is that number in this spreadsheet? So I don't think you're gonna see it here. It's when you downloaded it.
Hearing exhibit 4.
Okay.
It's not online, but
So the hearing exhibit, that number, that 502 number is not on hearing exhibit 3. Do we agree?
What was it for the third one?
The three
The web
is the
browser.
document that opens in the web browser, not the downloaded.
I don't care about a web browser, that changes every day.
That's not how.
So the web browser page that you went to there was the board presentation number that had the projections in it. And that's what was up there. It's, that number doesn't have the 502. The actual document when you download it does.
Okay.
And that is the difference. So and now I just have to looking to pull it up to myself because I can't read that thing. It's so small up there. I can't tell you. You say, look at it. All I see is blurry numbers. That is just that one.
The 6-month figure.
Yeah, just give me a second here. Oh, you know what? I actually already had it open for this because I planned to, I flashed it to you in the beginning. I zoomed in on it to be able to read it.
And that is hearing exhibit 4.
As I said, I believe that I inserted the wrong
It is
spreadsheet.
within,
So I'm going to need to enter it. It was at 502.
No worries. What are you displaying? Mr.
so
Wall?
I am displaying exhibit 4 as we decided it to be the downloaded version of profit and loss.
I think we got there. So if you download the link document, it displays more data that includes.
Just, I thought I was saying that. And I thought that's what you were showing me. And that's why I was so discombobulated. I also then couldn't read it. So yeah, that's exactly right. So the seller sent a file. It has a little online version of it in a preview. But I mean,
Can you explain a little bit why it was relevant to the decision,
so
whether to purchase a logic building?
sure. So, and you don't have any of this background, but most of us in this room do, I think. Is that we were going to buy, we bought the presentation to buy logic was fundamentally that we were going to occupy the office spaces in a multi-story building. We were going to, there was an existing daycare that was there that could be rerun and opened as a private daycare. And I think there was an interested party in doing that. And then to find a restaurant tenant to use the large restaurant that was on the lower level of this thing. So the reason that the revenue numbers are important is because the revenue numbers, there was a restaurant there. Someone was paying rent. There was food coming in. This is something, this is financial information of buying a building where you are going to lease it out to serve the same purpose, right? So when and I don't know if I don't know if I qualify as an expert witness, but I've looked at and bought businesses. When you buy businesses, you look at their profitability, which means you usually buy them with their EBITDA a certain multiplier for a number of years as the basis for pricing them. So their overall profitability times years is generally how those offers are determined.
Okay,
So the reason for, if we're going to rent two spaces out, right, that are going to be fundamentally serving the same purpose, looking at that information, if not for the revenue number, for the cost number, super critical. Like, how much did it cost to run the lights? How much did it cost to run the kitchen equipment? How much gas did they use when they're operating? There's a million reasons why that data is incredibly germane.
so Shorewood is going to purchase the building to serve the same purpose as it had for the previous owners.
That's correct. The only difference was in Shorewood's proposed model, as I understood it, we were going to rent the restaurant instead and the childcare facility instead of operating it directly with our own staff, right? So there was going to be we're going to receive payment in terms of rent instead of profits. We're also going to hire a property manager to then rent that out. So the way that I put all that together in my head is that the Moose facility should have been making more money than us rather than less in doing so. Now, I will concede that the COVID and the construction thing are real on their revenues. Like, that is a reasonable reason that we could have had an intelligent discussion about why we would ignore revenue. But use all the rest of the reasons why you would share a P&L document that I outlined a minute ago. Those still seem incredibly germane and like a foundationary fiduciary responsibility to a trustee to share information with his peers while soliciting their votes.
Okay, so what was the full square footage of the building?
I wasn't a trustee.
Okay, I'm just wondering, like, what is the share of these two nuggets, these two components compared to the whole size and breadth of the
I'm going to
building?
guess it was 2/3. Does that sound about right, Mark?
I don't know.
Okay. He would know better
I'm
than
not gonna guess.
nobody would know better than him.
Okay, so the village was looking to acquire it to be a profitable entity. Yes.
Yes,
Okay.
the basic premise of the pitch was that we would it would have positive cash flow implications for the village.
Okay. If you can pull up the email exhibit 5.
So those files you sent me in the break, are those numbered as well?
No, the email we already looked at.
Okay.
So I think that was maybe 3 or 5. The email. Great, okay. So this went to John's personal email, correct?
Thank you. Yes.
Yeah.
And his government one as
And
well.
his government email. It also went to one other government email.
Yep.
Whose is that?
That's Brian Mooney's and Chrissy Collis, actually.
Okay, who's Brian Mooney?
Brian Mooney is the village administrator.
Okay, and who's Christina Call?
She was the clerk.
And I apologize, some of this is very obvious, but we do have to make a record and
I am
these are
not,
things we can't assume.
this is much easier than what's in the file that I thought was a file that wasn't the file we were looking at a second ago. That's great.
And can you explain the process typically how public record requests to a village trustee or employee are handled? Are they all forwarded to a single person to assemble?
It's a really good question, and there's been some debate about it internally as to how it's been handled, because there's been staffing issues in our village. Open records requests are sent typically to the clerk's office in most municipalities, I believe. Taylor, is that right?
You can't.
You can't.
answer
Never mind.
questions.
What happens here?
So here we send them to the clerk and the administrator most often. Brian and Taylor are both copied on them, or at the time it would have been Chrissy and Brian.
Okay, so the clerk and the administrator typically get your public records request to fill them.
Mhm.
Okay, so
They then forward them to Computer Magic, our IT company, and our IT company returns them generally in about less than 5 hours.
okay, so what is the public record request that Mr. Imes refused to fill?
So in this particular case, off that little snippet, I need to check actually. Let's go back to the document real quick. That's our third section. So this is actually about the P and L. So at this time,
No, can you just, this could be a very long night. Can you just tell me what public record request Mr. Imes refused to fill?
Sheldon Lofty's request for the P and L, what John had is from financial information from the seller.
Okay, and when did that happen?
I don't know, it wasn't my request.
You weren't the requester.
I wasn't the requester. I am aware of the fact that it was made because this copy was circulated fairly broadly in the community afterwards with repeated attempts to get an answer about it.
So requests typically go to the clerk or the administrator.
Mhm.
And the clerk
Hold on
and
for a second. You'll have to answer out loud for the court reporters, so doesn't work. So you'll have to say yes or no, or
I don't remember what the question was to be able to say yes or no to it again. Sorry.
requests typically go to the clerk or the administrator.
I mean, I've been in this job for 3 weeks. I think so. Yes.
And the clerk and the administrator add this document in this situation.
Yeah, that's a whole nother thing.
Did Mr. Imes at any point say, go ask the administrator?
He said he didn't have, I showed you the other email there, at the end of that same section, which is the P&L one where it says, we never had one. And then when that was directly refuted by the actual evidence from the numbers citing, he then said, I had it, Brian had it, Mark and Bob had it, but there was no forthcoming, the document was impossible to find. Eventually, Trustee Lofty was in here, and John said, you know, you just get to go to, I don't have it here with me, I'll give you, go to Village Hall and they'll give it to you. And that was that resulted in a kerfuffle that's separate from all this. But
Could you, for the record, just clarify where in the evidence produced, John says, I don't have anything?
so if you look at this, yeah, I can. So the whole email trail that goes on from here, if I recall correctly, it's not short, right? It's a bunch of questions like, hey, where is this? And
Sure, can you just point out where?
yeah, I got it. Yeah, sure. This is going to take a long time. You weren't kidding.
Oh, you're saying he committed a crime for declining to fill a request, so we're gonna take the time.
That's fair. This is your exhibit, right?
Yes.
So if this is your exhibit, I may not have the full email trail on this particular one. This is your exhibit.
Okay.
Um,
We can also pull up.
Let me just check here real quick. Where
The whole
third one. Sure. That's why that's there. John Imes, Gloria Beach, Brian Mooney emails. That's the MailChimp one. The decisions or our request still pending to remedy you 3 specific emails from the MailChimp.
Are you expecting
no.
the reporter to follow that?
Oh, I'm sorry. Keep my mouth shut. I forget that you have to do that.
I'm hoping the Zoom is picking up some. It's very difficult to hear you when you're down there.
We can table it for a second and then maybe during a break, you can point out and
Okay. Yeah.
so. Do board members get public record training?
I don't know.
I'm sorry.
I said, I don't know.
Okay.
I believe the answer to that is we had a meeting with the league where they gave us some basics and invited us to take some courses. I believe that's a new process. So the,
Call for if you get correspondence to your, something where your personal email address is also CC.
so that's a good question. Generally speaking, if it's CC'd, most I have seen respond with their village version, not their personal one, because they're just CC'd, it's the same one.
So I'm talking about record retention. So if you get an email to your personal email address and it's about government business, what's?
I have no idea.
And so. Did you receive any text messages about today? Did you receive any text messages about this hearing in the last couple of days? On your personal device?
I'm not gonna tell you.
In the last week, has anyone texted you about the removal?
Yeah. So, yes, and I still have those.
Okay, have you forwarded them to the village administrator?
No, but I don't believe that's standard practice for most folks to do unless somebody requests it. And these are after your request. I supplied you the ones up to the date of your last request. You asked me in the last couple of days, your last request date was Saturday or something like that. So these would have, the ones I just see in here since then are since then. So nobody's requested that yet. But yes, I have them.
But if no one requested them, you weren't going to, give them to the village administrator?
That does not happen for anybody here that I'm aware of. Is that correct?
Nobody else can
No.
answer.
Okay, I didn't know that.
Well, it's just curious, you have government business on your personal device. Correct?
Yeah, yeah.
And it sounds like John Imes had a email that had his official email and his personal email on it. Correct?
Yes.
That also included the village administrator and the clerk,
Yep.
who typically handle public records.
Yep.
So would you agree that if he was trying to hide a public record, that would be a really peculiar way to do it?
So the one that you put out was on November 4th, and that was after the fact. After being called on it for quite a long time about it, that was him including that out. You want to pull that back up again? I believe that what you have up there is him saying, hey guys, now do this. It's true that the original message from Ava Kenny did have, it had John's email address on it with the here part. So if we go and scroll up a little bit.
You go down.
So the one we just read was him on November 12th.
Right.
So this is him now, and he's since admitted that he had this. So this is him sending it to his, so this I believe is where it goes onto his personal record, if you know what I mean. I can't explain the Brian and Chrissy part. But Ava Kenny, oh, it is on that one. That's interesting. So we'll keep it September 3rd. So in my opinion, that should have been returned in the open records request that went to the village.
It was in the possession of village officials, though,
Oh, yeah.
on official email servers,
Yes.
which record custodians such as the administrator or clerk can pull without even asking the requester or asking John Ives.
No, that email right there. Yes.
For example, when I manage public records for an elected official, I just go into emails and pull them out and fill them. So that could have happened here too.
By the way, with emails, I have already started forwarding that go to my personal address into my village one as a matter of course. I hadn't done that with my text messages, but that's probably good practice.
But
This-
your charge one is that he committed a crime here.
I would say that because of the fact that she included him there, that is part of it, the village. Now, the question is why the village didn't fill it, right? But that may not just be John. So I would actually concede that that seems like a good point. The village is really there's more than John involved in that problem right there.
And so
That shouldn't have
like
taken
the
4
text
months.
messages on your phone, when does it become a crime in your opinion for them to be on your phone?
No idea. I've been in this job for 3 weeks. And I've had no actual training on it, so I can't tell you the answer to that.
That is all my questions on the public record stuff for now. I think.
So, but you're right. In this particular case, John was asked, and Brian and Chrissy, and Julie, they were all asked for this document to return it, and it was never able to be produced. And this actually became a point of serious friction in the village, that resulted in news stories and the whole nine. And all 3 of them knew that it existed and were copied on it and had discussed it and cited it. It doesn't make sense to me.
Now, claim 2 is based on what you think were conflicts of interest, correct?
Yes.
Okay. And that's because the organization for which Mr. Imes is employed and runs has received donations from organizations that had business before the village, is that correct?
So I want to correct one thing. You said that I think that. That is what is accused in the document that I authored. I just want to make sure that I'm clear about that. I expect I've never asked the other questions with P&L publicly and on email. John and I had exchanges about it. That shouldn't be a surprise to anybody. But the conflict of interest stuff, this came up later. So I be careful about this. I don't have there's not a formed opinion in this regard. I genuinely expected answers to these questions. So what was the question again?
So you have some questions about entities that have contributed to WI
Yes.
because they also had alleged business in front of the village, correct?
Yes, there are recorded votes in the meeting minutes.
Did you consult with the Ethics Commission at all?
Yes, the Ethics Commission does not deal with towns. They won't do anything that is small, so they don't do anything at all.
Well,
They only refer to the DA.
for complaints, yes, but did you call to talk to any of the staff attorneys about guidance on their ethics material?
No.
Did you review any of the ethics guidance on the Wisconsin Ethics Commission for local government officials about when a conflict of interest comes up?
Yes, I consulted with a private attorney and then a couple of other private attorneys in the neighborhood, and I spoke about it as well. The discussion to make sure that that my understanding of it was correct.
So village board members are they're unpaid positions.
They're unpaid positions. That is true.
Okay, so typically village board members have private employment.
This is right. Yep.
Unless they're independently wealthy, I suppose.
That's true.
Or perhaps retired.
Yep. And I didn't allege that this rose to the level of pecuniary interest, right? That's not what this charge actually says. It follows that theme. But again, that was a literary device for writing up the argument saying these are the themes that we're following. It's gross neglect that is the discussion here, I think, right? So whether or not there's an exception carved out for whether they are paid or unpaid, and I still believe under pecuniary interest, if the payment is direct or indirect, and they're the sole employee of that nonprofit, where you're going, if you follow all that logic, that would actually cross that threshold. But yeah, so the answer to that question is I did review this with people, and I think that you're taking it down a path for an exception that follows the pecuniary interest line that isn't really germane to the conflict or the gross negligence one.
So you made a complaint to the Ethics Commission,
I did not, actually. I called and asked for guidance at first and was told they don't deal with towns and
so they
villages.
sent you to the district attorney?
That's what they would have done. I
Did
did
you
not
talk
do,
to the
I
district
did not
attorney?
talk to the district attorney about this now.
And, but you agree that volunteer board, elected board members can have private employment?
Of course,
Okay.
we all do, I think, or did.
Yeah. Are you employed?
Yeah.
And so do you have an understanding of when someone's employment interests implicate a conflict of interest, or it sounds like you just put this out there as something that needed to be investigated?
So it's my understanding that according to Wisconsin law, that sphere of influence is one where they're in the same entity, something like the executive, something they're all share a board. That should be a required disclosure piece, like it's his own personal interest or family.
Under what?
I would have to go back and find the statute where that notion comes to be, but I believe it to be pretty still established in Wisconsin law.
Okay.
Nobody else has disputed that concept at all. This is the first time I've heard somebody even question it.
Well, under 946.12, which is the charge that you claim is implicated here, there has to be an intent to obtain a dishonest advantage for yourself or another.
Yeah, so I probably shouldn't have included the criminal statute numbers because that, I can see how you've taken all that literally when it was really meant to say, I was just categorizing them.
I didn't take it literally, I just took the words that they are. So you don't, do you have any evidence of obtaining a dishonest advantage for himself?
No,
So then that brings us to 19.59, which prohibits local government officials from using his public position to obtain financial gain or anything of substantial value for private benefit for himself, his immediate family, or an organization with which he or she is associated.
that's the one.
So do you have any evidence of him having used his public position to gain personal private benefit for himself or W? Yeah.
So I gave pictures and timelines and votes of a pattern of him pitching MG&E, Corbin and Clark,
Okay.
and Stonehouse, right? Where they're doing business during that same time period and category, right? On projects where the village TIF money was awarded to millions of dollars
Okay.
to that. So I would say, I mean, the question is not, am I accusing him of a crime here in that? I distinctly in that document, I think I even say I do not. It's about whether or not he needed to disclose and recuse because of the relationship.
And you think he should have
I
refused?
think that he clearly, I mean, if that is all true, right? If what I have in there is right, then I would, right? DMARC did, as an example. I would think so.
Let's just accept it as true for purposes of this line of questioning. So the Stonehouse development, according to your complaint, they contributed to WEI in 2019, 2020, and 21.
Those are what's listed in John's annual
So
reports.
that's the evidence you produced. So
That's all that one can without a warrant,
that's
right?
what we're stuck with. right?
Yes, though that's, yes.
So those are the years of contributions, 2019, 2020, and 2021.
Well, and then we have him doing business with Ella with them in 22, cutting ribbons, where he's still on the same job site, cutting ribbons with those folks at the same time.
Right.
So whether or not they're listed in his annual report or not, I would say that it looks like it's 2022 too.
Standing objection on the Ella stuff, it was not disclosed. But the year of alleged business you alleged in your evidence for Stonehouse development was 2023.
Which is also the year that John's annual report is not, it was hidden behind a download link where it requires a password. So I actually can't, I can't actually check that.
Did you ever reach out to the organization and ask a copy for it?
No. I mean, he has a chance to answer it right here. It's, if he says he didn't have any business with them, I mean, that's an answer to it, but I don't know that still just having for the last 4 years or 4 out of the last 5 years done business where they're listed as one of your contributors. And then,
Let's just go with the dates you've offered as evidence. Go to
Sure.
complaint.
sure, yeah.
Waterman and Clark, years of alleged WEI contribution, 2019 and 2021, correct?
Yeah, although that, I also,
You just answered the yes or no. Are those the dates that you have presented for evidence?
yes,
Okay. And the years of business alleged by the village, 2023 and 2024.
no.
Okay, what is the other year?
He also participated in the rezoning of that in 2019.
For the Boardman and Clark business?
No, the
I'm
stone
talking
house.
about the Boardman and
Oh,
Clark.
I'm sorry.
So 2023 and 2024.
No, but the rezoning of that in 19 as well.
Okay. Stonehouse development. We're done with Stonehouse development.
Okay, I'm sorry.
Boardman and Clark. Years of alleged WEI contribution work. Am I correct? You presented evidence of 2019 and 2021.
Well, so if you look at his annual reports, they've been on his board for a long time. I don't remember exactly how many years of it they are, but it's been a long time that they've been on his board. I don't, off the top of my head, remember which years they are. It's been at least those, but further back as well. Those are the years that are relevant to the exhibits that are cited.
Is the evidence you produced that they contributed to WEI in 2019 and 2021? And this may seem like a hassle, but it is your burden.
I don't mean to, I am here for this as well, and I know everyone's time is here for this. I don't mean to be annoyed. I just, yeah, but I had that, stone house. Where that, it's all in the PowerPoint where I highlighted it, so. Corbin and Clark, oh man. I can't read the year. This is the 2019 annual report. Is it there in there?
Let me just ask you this. Okay.
This is the,
Other than, so for example, let's just accept this for true for purposes of this exercise, please. I read your complaint to say Madison Gas and Electric contributed to WEI in 2017, 2019, and 2020, according to annual reports. And there was alleged village business that President Imes partook in 2024 and 2026, 4 years later.
that actually, there was an earlier shared solar program as well that he participated in that has, I believe, been entered into evidence and also was given to you as with in the binders of information that you requested. So
Yes, absolutely. We were given a lot of material, which is precisely
No.
why we asked for an adjournment and were denied it.
fair. Yeah,
Other than the dates, this contribution happened in 2017, 2019, 2020, and then the village acted on something related to this entity on this such and such a year. Do you have anything other than sort of pontificating about the dates to show personal financial gain?
no, it's the organizational crossover. It's not personal gain. It's the organization participating and benefiting side of things.
Do you do any other board service?
One other board, yes.
Okay. So for example, hypothetically, are you operating under the assumption that a legislator cannot be on the board of Planned Parenthood and vote to overturn the abortion ban?
I have no idea. I'm sorry.
Well, or is it your opinion? Can you be, let's say you were on the board of Planned Parenthood. Or rather, let's say this never, Kelda Royce is on the board for Planned Parenthood. Let's say this hypothetical.
Okay.
I'm just trying to understand where you're thinking of with this conflict of interest stuff. Would it be your opinion then that Kelda Roy could not vote on any legislation having to do with abortion services?
That's a really good question. And my understanding of it is that there would be a disclosure requirement, if I'm not mistaken. But that she would still be able to participate in voting is, I believe, how that goes. But I believe that there's a requirement to disclose for the potential conflict of interest. And if I'm wrong about that, I'm wrong about that. That's a real thing.
My client would like to ask a few questions.
Brian, I just want to address the allegation that the P and L was relevant to the transaction. So I'll just ask you some questions. Would you agree that the village was not acquiring a business operation, but was evaluating a real estate asset?
No.
So would you agree that for a real estate, for a municipal due diligence, that appropriate due diligence would focus on an independent appraisal of the real estate?
That should definitely be one of the things that is considered.
Did you review the appraisal on the Village of Sherwood Hills website for the real estate?
I did.
What was the value of that appraisal?
I think it was 8.5 million, if I remember correctly, is what GEC came up with. I don't remember off the top of my head, John.
I think the correct number was $7 million plus whatever the value of the FF&E was. And you're aware that the village offered $6 million for the purchase plus FF&E.
Yeah, I am. That's still for sale.
Are you aware that the appraisal also showed the lease potential of the square footage on the lower level at $360,000 per year?
So I will be honest, John, I was not impressed with that independent appraisal. It seemed overly optimistic to me throughout, and I had a lot of concerns about it, where it didn't seem super independent to me, GEC being our main appraiser that we give a contract to. There was enough about it that it didn't seem like those numbers were accurate. Like, for example, if they were offering us a building at $1.5 million less than market value, you'd think you'd buy it and you could resell it instantly, right? That building's still for sale, 6 months later.
We've talked a lot about the P&L tonight, and I don't want to extend this.
Okay,
I
fair.
appreciate the answer. I think the other thing I'll ask, and I certainly am not an expert when it comes to the finances of Moose International, but it's my understanding that that lease was structured to pay for the construction of a $14 to $15 million building. So that the way the lease was structured, it also paid for the construction. The construction of the building did not move forward until that lease was negotiated. Are you aware of that, or did you pick that up in your review of the finances?
I did not know that. I don't remember.
John ever refused to appear for any board meetings,
No.
or refused to vote or partake in official duties when asked? Other than the public record issue we discussed that
No.
you're concerned about?
Yeah, no.
Okay. And the logic, for the record, I know everyone in this room knows this, the logic sale did not go through.
It did not, no.
Okay, when did that vote happen?
I don't remember the exact date of when that vote happened. It was somewhere in the early winter.
Was it before or after trustee Lotfy obtained the, it seems like this,
It was,
more
it was,
P&L.
it was, I believe it was slightly after Charlie Lafayette had received that.
The vote
I
happened,
believe so. I'd have to go back and check, to be honest with you. And nobody else can answer, so I don't know. I don't know the answer to that question.
I can call on her case.
Sure.
Yes, if it's okay with both parties. may
She probably will remember. I don't.
I can answer any question you would like.
Please.
I obtained the PNL on October 15th, 2025. It was a Thursday. I distributed to the board October 21st or 22nd, 2025, after I had it reviewed by an accountant. And the vote happened the next day, October 23rd. So I got it on a Monday. I sent it out on a Monday and the vote happened on a Tuesday.
Okay, thank you for that clarification. That's all I had.
Yeah.
Okay, so that was cross-examination of a witness, is my understanding. And so did you, going to my outline, do you have any evidence that you would like to present?
We should see if anything else. Does the complainants have any other evidence?
So arguments is an interesting point because I wasn't allowed to do argument. I just did that. I was allowed to move to
Just
that.
one second, just one. Mr. Butchick, do you have any witnesses to call?
Yeah.
Any other further evidence that you plan to introduce?
No.
Okay, so Attorney Deely, do you have any other witnesses you would like to call or evidence you would like to submit?
Yes, I'll ask John generally to answer any of these questions. I think he's happy to answer questions. I also do want to point out there were multiple points during the back and forth before where Trustee Utchig said that there has been or there will be opportunity for us to submit contrary evidence. To be clear, the burden is on the complainants. And we could rest and stop and do nothing, and it would still be on their burden. Is that the understanding of the board?
Yes.
Okay.
Does anybody need a break? A 3-minute break?
Okay. Just for record, Mr. Wall, could you tell us can you just run down what the exhibits are so far and then make sure we have a clean record with what we.
So I have exhibit 1, the PowerPoint presentation that Trustee Uchig provided. Exhibit 2 is the 180 some page packet, or 168 page packet. Exhibit 3 is yet to be uploaded. It's going to be the screenshots of the web browser that DML document.
And to pause, that is derived from the link on the email we provided,
Correct.
right? Exhibit 4?
Is the downloaded version Excel spreadsheet of that document, and exhibit 5 I have as the email labeled paren to Gmail forward 2801 Marshall Court, namely that email that has the here link.
So then I actually stand corrected because we didn't actually note to enter the information on the Ella, which I know you objected to, but I would like to enter that into the record. So I will send that to you here shortly, Taylor, but I'll get the screenshot and the source of the file for you to be able to pull the link down. You don't have to search for them. But I would like those entered into the record as well.
And then if we may enter into the hearing record for clarity of record, Exhibit 1 of Mr. Imes' declaration is presently marked here in Exhibit 5. If we can enter Exhibit 2 of Mr. Imes' declaration as hearing Exhibit 6. And Exhibit 3 of Mr. Imes' declaration as Exhibit 7. Exhibit 4 of the declaration as Exhibit 8. And Exhibit 9 of the declaration, or 5 of the declaration as Exhibit 9. If we could enter the declaration as itself as Exhibit 10. We could enter exhibit or tendered hearing remarks as Exhibit 11. If we could enter the May 6th recusal request as Exhibit 12. And that would include, it's got attachments. I think that can all be one exhibit. And if we could have the May 6th denial of the request for recusal and denial of request for more time and postponement as Exhibit 13.
May I ask a question about procedure? Because earlier I wanted to make sure that my statement about recusal was entered into the record as an exhibit. And being that is being the question for it is being asked, shouldn't my response be included as well?
Would agree.
Okay.
No objections.
So
Is that
then
14?
it would be 14.
Can we reiterate what exhibit 14 is?
It's my recusal response.
Which I believe you read into the record.
I
correct?
did read it into the record. This is true, but I did also print it here. So it's on the OneDrive for you to grab.
And a point of clarification, if I may. Exhibits 7 through 9, are those the PDFs you sent me? Okay. Thank you.
Yes.
Do you have any further to this?
No.
All right, we should clarify, you said you wanted to submit something else.
That was that.
No, but there was something you
Oh,
mentioned.
the
about
Ella, the information about the Ella for Stone House, where John's at the ribbon cutting ceremony and the Ella house, that was not included in the packet. That was brought to me later as an example of Stone House from a resident. So it was included, and I've already, I'll have that to I will send that to Taylor here shortly.
And then that would be 15.
Okay, I think he counted it though. Did you include the Ella information earlier?
Is it in the PowerPoint?
Yes, there are images of it in there, but it doesn't
I
say.
don't think it needs to be duplicated.
Okay, it's just the the source is the WEI website and the Ella website. Like they're just, that's all it is. It's the website at the Ella and the WEI website there. It's not a super secret find.
And what number are we on, Mr. Wolf?
So if we are not making exhibit 15, the Ella website here on exhibit 15.
We would also enter in as Exhibit 15 an email regarding the renew the blue. One on what?
Have we seen that?
No. It's rebuttal for.
Why would you not? Okay. Do we get to see it?
Of course.
I can speak to it.
Yes.
I thought we'd ended the evidence production phase of the thing. I thought we were in just the categorizing at the end of it. My bad.
No, my hope was that if you do this all now in one swoop, it'll make it less painful, timing wise. Mr. Uchig, you can keep reading. I just have a administrative question for. Trustee Lutfi. Our verified answer, you, just to ensure it's part of the hearing record.
I'm sorry, I didn't get the end of it. That's okay.
Our verified answer is, should we move that as an exhibit, or will we assume that gets part of any record on certificate?
I believe it was part of any record on certiorari review, but if the parties want, we can put the complaint and the answer in as exhibits as well. So why don't we do that just for a belt and suspenders approach? So the complaint, the exhibit 16. And the answer, exhibit 7.
This is not a stipulation that something has to be an exhibit for it to be part of the administrative record, but it might make things easier down the road. Okay. And as to that email, Trustee Upchik, that's the only thing that is additional. Everything else was tendered before yesterday. Verified copies tendered today.
This document does not have on it. So it ends on the June 18th date where it says, "Greetings, John. Thank you for your agreement for Sherwood Hills to be a member of the Renew the Blue Watershed Council. My name is Mike and I'll be the main point of contact."
If you can pause, that is a court reporter's worst
Oh.
nightmare when you read fast from a document. Do you mind if we just speak about the document in the course of the testimony and you look them up?
Oh, sure. I'm sorry. Yeah. Thank you. Can I hold on to this or do you use that your copy?
Well, we start questioning, is someone available to make a copy of this document? Otherwise, we can do it during a break. My apologies for the inconvenience.
Upstairs.
Maybe during a break. Okay. All right. I may call witness. Break. Is that what you're asking, Rocky?
It's been a long time.
Okay, we're gonna have a 5-minute recess.
Sorry.
You're fine.
Tell her that.
Where are you going? You're in Europe. Is there still skiing there? They should ski.
Hopping from left barrel down, not more.
I'm the opposite. I'm
Yes. We don't, none of us all kind of ski anymore.
That would.
I'm gonna frustrate us because you know, we say you're every so far. I can't obviously. So she's just sitting there. Yeah. It's just. Eventually.
Yeah.
Water too. I'm gonna type this out so that.
Sure.
Well, exhibit one was the power here. Exhibit two was the appendix. Oh, there were three.
Was the,
Okay.
Or not established.
Yeah. And so here's Put down the link. Something more. But again, I think it's.
Sure.
I'm definitely.
This is goes. No, actually, it's.
That's it.
This is exhibit five.
Okay, so exhibit, I'm gonna write declaration exhibit. One. That's the way that is. But then is the act declaration not included?
No, the act declaration is
All that. It's a 12 days. Letter, okay.
And there's the design.
It was gonna be the complaint. It's exhibit 16. Exhibit 16 is the answer. All right. Is that right? Right.
Exhibit 16 is the original.
Okay, do we have a 15?
15 is the email renew the blue.
Oh, yeah.
Okay. 1 second.
And is the complaint, not 17, the answer.
Renew the blue email and
Yes.
we haven't started yet. So the court report is okay.
I have not taken.
Oh, okay, perfect. Okay. We're gonna reconvene at 8:55. Attorney Dewey, the floor is yours to call your next witness.
Okay, I will call John Imes. For purposes of the board consideration, all the exhibits that we've already tendered in advance, can I assume that the board has reviewed those materials without needing to go over the content in live and hearing?
I'm gonna look to the board members to just for nod heads, head and head.
Here, I will actually, I will call each on the record. Trustee Barford, did you review the verified answer?
Yes,
And did you review the declaration from Mr. Imes
yes.
and the attachments to the declaration?
No. Unless that's the affidavit.
Yes, so
Yes,
the
yes.
affidavit that has exhibits attached to it?
Yes,
Okay, did you review those attachments as well?
yes,
Okay, and did you review the under hearing remarks?
yes.
Same question to you, trustee Letterer. Did you review the verified answer
I did,
and Mr. Imes' affidavit
I did,
and the attachments to that affidavit
I did,
and the hearing remarks?
I did.
Thank you. Trustee Upchig, same questions to you.
Yes, I thought I already answered them, but yes, earlier, but yes.
Okay, so you've reviewed all of the declaration or affidavit, it's also known as?
Yeah, won't remember them by number. If you just say in that declaration 5, I'd need to be reminded which one that was to jog my memory, but other than that, yes.
And you reviewed the attachments to the affidavit?
If you recall, I remember, I think I even cited John's I'm other as an example, which should serve as evidence that I did.
Yeah.
Oh, yes,
And you reviewed the hearing remarks that were emailed last night.
the email that you sent last night, repeating a request for recusal in that one.
Nope, the email with all of our responsive materials, the declaration with attached exhibits, our verified answer.
Oh, yeah. The one that had the affidavit in it that came later signed. Yes,
Yes,
yes.
and there was also an attachment of hearing remarks.
I need to go look at which one that was. I did open and read everything that was in that email. So
Okay.
I would think the answer is yes.
Thank you. Trustee Lotfy, did you review the affidavit and the attachments
Yes, I did.
and the verified answer
Yes, I did.
and the hearing remarks?
Yes, I did.
Trustee Van Asten, same questions. Did you review the declaration or affidavit and answer and attached exhibits?
Yes,
Okay. And the verified answer
yes,
and the hearing remarks?
yes.
Thank you. Hopefully that will.
One online.
Oh, yes. Thank you. Trustee
Also,
Alcevic. Did you review the affidavit and its attached exhibits?
I did, yes.
And did you review the verified answer?
I did, yes.
And did you review the hearing remarks?
Yes.
Thank you. Hopefully that will save folks. From tonight. Okay. President Imes. Have you reviewed the complaint against you in this case?
I have.
And the first allegation is one of perjury, misrepresentation, and or false statements to a legislative body. And this all goes back to this September 3rd email with the link document. Do you remember getting that document?
I'm sure I received it, yeah.
Do you remember reviewing it?
I definitely reviewed it.
Can you explain? Well, did you tender it to the entirety of the board before the next day's hearing?
I did not.
Okay, can you explain what went into that decision?
I think we have to be careful with open meetings laws for me distributing stuff to trustees. So if I send it to more than 2 trustees, that's a violation of open meetings laws. We're meeting behind the scenes on notice of the meeting. So the fact that it went to our village administrator, who was maintaining all the records associated with the lodging position, that's where trustees would go for any information or questions that they had, part of their own due diligence.
Now, your personal email is on that exchange. Do you have any idea why that would have happened?
I imagine it's because I gave whoever I met on the tour, Ava Kenny, my business card, my WI business card, which has the johnsouther@gmail.com email on it.
Do you have any other personal email address?
I do not.
And but ultimately, you did respond with your personal email address. You understand that that's not good practice for an elected official.
It has been pointed out, and I always viewed it as a kind of a fail-safe. I have 2 other Outlook emails.
For what?
For Wisconsin Environmental Initiative. So one that goes back, the organization's in its 30th year. So I have an email that's still out there, jimes@wi-ei.org. And I have a jimes@wi-greener.org. And with the village also being on Outlook, that can get kind of complicated in terms of keeping things separate. Most of my WI correspondence now is done with the Jimes Other.
Okay.
Just for a productivity standpoint and my ability to keep track. That's what's best.
Okay. Have you ever refused? Do you remember ever refusing to turn over a material that was solely located in your personal email account?
No.
The September 3rd email with the linked document that seems to be sort of underlying a lot of these claims. Is it your understanding that the village is the authority of public records?
It is.
Okay. And that the authority have access to your email? That they could have pulled that email?
Not from my personal email account?
Right.
No.
But from your work email?
Oh, absolutely.
And what about the village administrators? Same deal?
Absolutely. Yeah.
And the profit and loss statement that you accessed on September 3rd. Do you remember why you said the things you said about the revenue numbers? What did you derive from that document? What conclusions did you make?
Yeah, from my standpoint, and I think from the village's standpoint, this was not the driver for the real estate transaction, but I was interested to see what the revenue numbers are. Because we were being very conservative about the revenue potential of this building. It was more of an add-on. And we were estimating that the annual revenue generation for that square footage on the first floor was about 12,500 square feet, about half the 25,000 square feet building, was about $300,000 per year. We were seeing rent of or revenue of $300,000, $400,000, $500,000 per month. So we were being very, very conservative.
Well, to be clear, that's where did you, when you say we were seeing, where did you see it from?
From that 12-page document that was part of that September 3rd.
Is it possible you misinterpreted that document?
Absolutely. So I'm certainly not an expert on their business model. And as I said, we were told that, their finances were driven by a lease to pay for the construction of the 1415 building. That's going to completely change the finances.
How so?
Because you have to create a lease payment that's going to pay off $15 million. Yeah. So it's not like a building was built and then they opened up the building for lease. So it was a lease. It was like, we will build this building for you. But we're structuring this lease to pay all the costs, the operating costs, but also the construction. So we didn't evaluate it from that standpoint. We were just like, it's completely different.
Just so I understand. So if there was a loss, a lack of revenue, it would have been in part been attributable to paying off construction?
That's correct.
Okay. But in any event, you can see how other members of the board might disagree on the relevance of that document.
Absolutely.
And so in retrospect,
Well, I mean, I think in retrospect, when we even talked about it in the fall, it was like, what we should have done is had a Dropbox site or had a whatever Taylor's got right now, the one site where everything just goes and then trustees can access. Because where we get into trouble is when it's like, okay, I've got this document and send it to a trustee requests something. If I send it to them, and then if I send it to anyone else, now we've got the meetings violations. Now we're meeting behind the scenes. We're doing the people's business behind the scenes without having an agenda, minutes, and transparency. So it always makes sense to have everything at the village to be accessible.
who was responsible for assembling due diligence materials in the purchase?
I would say our village administrator. Because everything that we did was also posted and is still posted on the village website under the modern facilities page.
Did you end up voting for the Logic Building?
I did not.
Did any trustee vote for the purchase of the Logic Building?
I think both Mark and Bob did. And obviously I was criticized for being an advocate. And I acknowledge that criticism. I thought it was a really good idea for. I know there's people in this room who I really respect, who were definitely against this from the beginning. But also once they reviewed the due diligence and looked at the appraisal and looked at the work that Mark and Falk did, changed their mind and said, no, this is a good thing. And despite that, I voted not to move forward. And for me, it was, we had a lack of consensus in the community. We certainly had a lack of consensus on the board. And quite frankly, we were out of time. We were hearing from the bond council that you have to decide on this. We were coming into budget season. We were finalizing the budget. We were finalizing the CIP. We were doing multiple CIPs and multiple budgets, depending on whether or not the Logic transaction was going to move forward. And we just got to the point where there just wasn't enough time. And then just from a vote standpoint, I didn't want to have a 4-3 vote out. And where, you know, that single person is always exposed to, you didn't support it or you did support it. And so with the lack of consensus, I voted not to continue.
Have you ever, well, I guess, when you are at a board hearing and performing your official duties, are people under oath?
Fair enough.
So when you spoke about revenue numbers, let's assume they were wrong. Were you under oath when you made those statements? And even if you were, did you intend to give erroneous numbers? So did you knowingly make any false statements?
I did.
Have you ever intentionally used your private or personal email accounts to conduct government business so you could avoid the public records law?
I have not.
Is there anything you want to say on the September 3rd email issue? Yeah, the P&L stuff. Any additional comments you'd like to make to your colleagues?
I guess that's what's.
The P&L stuff. Did I miss anything in our summary of?
No, I don't think so. I mean, it's my understanding that the detailed P&L was not something that I ever received until midnight on October 20th, along with everyone else.
So that link, when you clicked it from Ava, do you know if you downloaded the document to see the different tabs?
So the only thing I ever saw was the 12 page, which you went through on the overhead.
Did you know that it would have different information if you downloaded it?
No.
On the second claim, the conflicts of interest claim. So I'm looking at exhibit 17, page 9. I believe that's our verified answer. Has Stonehouse Development, as far as you know, contributed to WEI?
No, in the past, they, built affordable housing units, which include green-built certified units. WEI is the main certifier for affordable housing units statewide.
What about Boardman and Clark? How have they contributed to WEI?
Boardman Clark is a founding board member of WEI, went back now almost 3 years. They have not contributed financially to the organization, I think, since 2017. And that was like a $2,500 per year contribution.
What about MGE?
Madison Gas and Electric hasn't been a board member for some time. They were contributing support to the organization. I think the last time was 2019.
And what about Renew the Blue Council?
Renew the Blue is a new engagement, and the exhibit that I passed out. I know the claim was, boy, John approved this and moved forward. So I just like to read from the email in June of 24. And I'll just paraphrase here. I was responding to the staff person for Renew the Blue to thank you for the thoughtful introduction and for sharing these materials with us. We appreciate the clear overview and the opportunity for Sherwood Hills to contribute as a member of Renew the Blue Watershed Council. We look forward to reviewing the documents in detail and presenting the information on an upcoming village board meeting for discussion and formal action. And then, so that meeting happened in August of 2025. Board supported, I think unanimously, our engagement with the organization, agreed to appoint me and village administrator Brian Mooney as the representatives. The agreement for that partnership was not signed until September 1st. And the invoice was not paid until September 18th. The complaint suggests that, this was a done deal back in June or July. It just wasn't.
Well, and here's the important question for purposes of an ethics violation. Have you ever personally benefited from your official action involving Stonehouse Development?
I have not.
Have you ever exchanged official action for contributions to WEI?
I haven't.
Have you ever, same question for Boardman and Clark, have you ever agreed to give work to Boardman and Clark in exchange for personal enrichment?
No, in fact, when we changed law firms last year, Boardman and Clark expressed interest in providing additional legal services than the HR services they had provided for, as far as I can know. That's when I started in 2012. And I disclosed then that Boardman was a member of my board, and of course we went with Axley as our village attorney.
So you disclosed then, why didn't you disclose the other two?
Well, yeah, when we've had discussions with attorneys in terms of our attorney, in terms of general purpose engagement, kind of association type things, that did not rise to the level. I think the complainant talks about the comparison to former village trustee Dietmar Busuner. Dietmar works as a vice president and senior project manager at Rupp General Contractors. They're a company that does $7.4 million in annual revenue focused on commercial construction, development, and multifamily residential projects, including projects here in the village of Sherwood Hills. So, when we've talked to our attorneys about this, it really was a magnitude. It was really there was a financial arrangement. There's a direct linkage. This was general purpose. This was association, and always got that feedback from the village attorney.
Okay.
This is bad.
So I think what you're getting at is the ethics guidance from the Wisconsin Ethics Commission, that where you're securing benefit that benefits everyone equally, just as it may an official, there's no conflict of interest. Does that sound familiar?
Yeah, it is familiar, yes.
Okay, and for clarity record, you've never agreed to vote on anything in exchange for a contribution to WBI,
That's correct.
or for you to be personally paid for anything. You talked about public records. Have you ever destroyed a public record?
I have not.
Have you received any comments or statements from your colleagues on the board indicating that they've already decided how they're going to vote today before coming into the hearing today?
I think you talked about those earlier this evening.
Okay, did I miss any?
Not that I know of.
I mean, in a moment. No further questions.
Okay,
Do I get a chance to?
that's exactly what I was about to say. Trustee Uchik, the floor is yours. You may cross-examine the witness.
All right. A legal ego moment. Never thought I'd get a chance to do this. All right. So let's start with the last one. Would you agree that when I had sent you that message that was cited in the example, John, that was 6 months ago, I wasn't in public office, and I have not contacted you about how I intend to proceed in this hearing?
I'm not sure I would agree with that, Brian.
How not?
I looked at agenda and my counselors spoke to that. We had an agenda for this meeting where there'd be a vote on removal of the village president. I think it was item 12.
Mhm.
Item 13 would be appoint the new village president. Item 14 would have been appoint a new trustee. And item 15 would be let's approve a slate of committee chairs.
So I think we should enter that right into record. Actually, that agenda then, if is already entered in, great. Because the actual word is possible, possible, possible. So depending upon what the findings here were, if that happened, that was the suggested course. But it wasn't an assumed, John. Is that the only example you can point to then where I've commented on any kind of prejudgment at this event?
Yeah, I won't provide additional.
Right. You mentioned not having used your email or personal email for public action. How do you?
Objection, misstates the testimony. He said he has never used his personal email to take official action with the intent of abating the public record law.
Okay, then noted. we'll leave that one then. The Renew the Blue, I need to actually read that document again, but it does on its face from the beginning to the end look like it is a good, like that one might not be right, which exculpatory evidence is, that's a good thing to find, not a bad one. So the one thing that I see that's missing from it is the initial email, it appears, because he's referencing an email from you in the last email that comes, but we can't see what that is. So there's no way for me to see if you've agreed to join that and then that come. So while it looks like it's exculpatory, it's one record short of actually being so. So if you wouldn't mind, I'd like to see that expanded up, but I'm going to, I'd like to take it on good faith that that is going to be there, but it's not there actually. You want to look
Did you
at
want me to
it?
respond to that?
Yeah, do you want to look at it?
Yeah, I mean, I'd be happy to look at it, but I think the issue, Brian, is that and have discussions with entities and have some initial discussions about whether or not something's worth considering, worth joining.
Yep.
And then preparing the materials for a board meeting in
Yep.
August for consideration by the board. And then that's an opportunity for the board members to look at the packet, look through it, consider it, put forward a motion,
Yep.
second it, discuss it,
Yep.
pass it unanimously,
Mhm.
and agree to a dollar amount, and
Yep.
agree to participation level,
Yep.
and then have the actual agreement signed 2 weeks later.
Yep. And then pay them
and the
later.
invoice paid 2-3 weeks after that.
So I hear all of that. And like I said before, on its face, it looks like it's exculpatory. It looks like it answers the question about it. However, what I just want to make sure that we hadn't committed to joining in the original email that he's thanking you for. And that would be the difference. So I just want to check it just to make sure. But it does.
I think, I'm sorry to interrupt. I just read for the audience and for you that, approval was contingent on board discussion. That's in the document that you've received.
That's true. You did say that in a later thing. So if that's the case, that one likely goes away, right?
Just a reminder, it's your burden.
Yeah, I understand that. I meant from me. I told you I was coming into this looking for, I hoped to find all this stuff answered. I know that sounds strange to you, but it's true.
This is an opportunity for cross-examination of a
Fair
witness.
enough.
It's not an opportunity to argue.
Thank you.
Either one of you. If you have questions, please ask them of the witness and respond to the questions.
Fair enough. Apologies.
So green-built homes, just for a second, John. You mentioned green-built homes certified. Is that the majority of your revenue, the certification?
It is.
It is. And so when someone builds houses, those units get certified and WEI gets paid for certifying units.
Right.
So those wouldn't be donations and classifying them as supporters. When you list supporters, are you listing clients that bought units or are you listing supporters that give money separately from the units?
Those, with respect to the Greenbelt projects, those are like service revenues. Those are not classified as contributions.
Okay.
Those are program revenues.
Yeah, but you just list supporters in it. So I don't know how you're classifying them, and that's what my question is asking.
Yeah, well, I mean, you've seen our tax forms. You've obtained our tax forms. So that showed where contributions were and where program service revenue.
But almost all of your revenue is in that, and then there's no breakout of what those are. So you have a breakout. You don't have a form. I think it's exhibit. You have a form F attached to it. So you can't see what the breakout is of those companies that are buying those services. So, go
ahead. You ask questions.
No. And so it's that isn't clear. For example, that Stonehouse isn't certifying houses through those years. If you look at your tax forms that are available, you can't publicly, you can't see that. Would you like to add to that?
I think we can move on.
All right. But Stonehouse, you said didn't contribute. Well, the last year they certified homes with you was what?
I don't have the data in front of me, but I think it was the last of it was before the dates that you claimed in the complaint.
So
It's
in,
been some time. It's been 6 or 7 years.
so in the case of the Ella, for example, which was, I think it was built by Flad? Who's it built by? Krupp?
No, that's New Year's development, I
Is
think.
it they that then would certify it, not Stonehouse? Because it's,
That's correct. I don't think that was a Stonehouse development.
Stonehouse was the builder listed on the website.
Okay. The developer pays the fee per unit.
Okay, so it's
Agreed with
possible
this
that
certification.
Stonehouse built it, you certified it, but a third party bought the service from you, all on the same project.
Yeah, the company that does the construction does not pay the fee. The developer pays the fee because the developer receives the tax credit from the.
I see. So, okay. Um, Now, we're gonna jump back, if you don't mind, to the revenue numbers quickly. You mentioned that uh, the lease was financed, where they were paying it off in time over on the revenue numbers, which suggests the drag down. I just want to, may I share my screen for a second? I want to ask you a question real quick. Go back to Zoom.
Can you find out what exhibit?
Yeah, it's the exhibit of the downloaded form from Ava Kenny that we have struggled with so far before.
Exhibit
4.
4.
Thank you. Sharing is not turned on, Taylor, so I'm gonna have to ask you to do that, sir, if you don't mind.
So I will relinquish my iron fist on the shareability of everything. Check.
While we're doing that, John, do you mind? I want to go jump over to the ORRs real quick, open records requests that were for your personal devices, like, for example, the ones that Gloria Beach or David DeVito had requested. And the response that came back to them and me actually once from Julie was that the village is not required to produce records that they don't have. But they didn't ask them of you or direct us to you to get them. Were you aware of those requests? Gloria, you were copied on the exchanges with Gloria and David, right?
If I was copied on, I was aware of it, yes.
Well, why didn't you fill them earlier? Why did that take so long? Why did that take
I
months?
think I was working in cooperation and collaboration with the records custodian, the Village of Sherwood Hills, and I was taking feedback from Julie, clerk treasurer, on what I was required to do, and as you know, I did fulfill those requests.
Eventually you did it after Taylor talked to you about it, after we had yes. Can I share now? Good. All right. So these, sir, are the revenue numbers. And what I want to point out, I know this is really hard to read, so I'm going to zoom in. I'll just zoom in over here and do this. Okay. So these are the revenue numbers. You know what the EBIT-R on there means?
I do not.
Okay, so that is minus rent. So it's the EBIT minus rent. Instead of amortization, which is a normal A that goes on there, we put R on there. And that is calculating in the cost of the buildings against it to make sure that we're rectifying those numbers that you're talking about. And these negative numbers that are being reported here are the real numbers, right? So even after it lost 105 in actual revenue, even after you put the cost of the building, the value of the building back in, that data was something that was, had you downloaded and looked at what the seller was there, and again, we talk about what that means at another time. The fact that it was losing money was a pretty clear thing looking at the numbers,
Brian, I explained to you in writing, and I've said in this forum, and I've said in other forums, that the operating model, the Moose International model, was not relevant to the due diligence we were doing. And that's reflected in the work that our finance director, Mark Lederer, did as a trustee with a tremendous financial background, and the work that Bob Falk did, an independent professional appraisal, our evaluation of the space, our evaluation of the environmental and ADA issues.
So,
And so, you know, in a less than a 2-month period, we had to focus on things that were relevant to a municipal real estate transaction, not trying to parse through or understand all the minutia, what apparently was a failed business model. And their board decided to move on. And we would have been in a situation where we could have obtained a building for half the cost it would cost to build today. And so that's why we saw the value proposition, potential value proposition for the village.
okay. So, real quick though, let's say that all of that is true on its face. Why did you? I understand you said that the reason you didn't share it more broadly, other than to 2 other trustees, was for open meetings concerns.
I think that's one of the reasons, but there has to be a place where everything is, and that's the village hall.
Well, that wasn't the question though. So the question, that's what you said. That was just me saying it. I'm just repeating it just to get the question out there, right? Now, the question is, when Kate Ulsvik created her own P&L, trying to figure out what it was and do her own financial analysis with her education in the topic, or when I, as a member of the public, said, hey, you obviously have some financial data. Where is it so we can see it, right? You did not share that information with anybody else. In fact, if I recall correctly, you denied that. Actually, I have evidence of the thing. It looks like what you just did was deny that you had it until we could demonstrate to you, where it seemed like it was impossible to refute that you didn't have it. So my question is, why was that? Why was it not? Why didn't you just give that to Kate and Shabnam and Dietmar and Carol?
It wasn't requested of me, that's one. 2, I didn't have the detailed P&L that everyone talks about. I never had it. And
So-
the village checked with Computer Magic on that. We never received it as a village. I never received it. We didn't get it till midnight, the day before a board meeting where we took a formal vote on the 21st. But we had already decided on October 15th, we weren't moving forward. And we didn't do anything between October 15th and October 21, because we had already decided there was no consensus. And we're not going to move forward with this transaction.
Okay. So, and I'm just remembering being here on the other side of that, trying to get that a hold of that information or to see what it was. And even the high performance summary that, or the board performance summary that was up there that you did have access to, right? The one that was on the first email that said here that you pulled those numbers from, at least had some data in it. But even that wasn't shared, right? And then why didn't Computer Magic return it? Do you know the answer to that? Like, it said P&L in her email. It went to you, Brian, and Chrissy. Why was that record request not fulfilled? How could that possibly have disappeared into the ether? Do you know?
I don't know. I know that I made every effort to share whatever information I had, or to work with staff to share whatever information the village had on any request. So I disagree with that. I refuse to provide information on financial information that we received from Logic with respect to their operation that was provided.
Okay.
And to be honest, there was no reason to withhold it, because from my standpoint, I think from Brian Mooney's standpoint, I think from Mark's standpoint, and Bob Falk's standpoint, and others that were following this closely, it wasn't relevant to the deal. And we needed to, pretty short order, make a decision on whether or not this was a viable, relevant transaction for the community moving forward.
So So as a village president and doing this, and you're asked for information from the seller, right? You email David Kenny.
Microphone.
Oh, sorry. Sorry about that. Why didn't you download the file to be able to look at it? I mean, it seems like that's the kind of thing that you download to me.
I did not download it.
Okay.
And to be honest, Brian, we were just looking for whatever information that they had. I mean, eventually, Mark and Bob had an interest in what are really the operating costs. They were trying to factor that in. We found out that Logic was spending $60,000 a year on cleaning. It's like, how is that possible? Well, it was COVID, and those were shared offices. So every time someone rented an office for an hour and left, someone had to come in and clean the office. It was like, okay, we get it now. But to make a judgment on those spreadsheets that related to that business model and to apply it fairly to what the municipal Village of Sherwood Hills was going to do with it.
Yep, and I will
It just
concede
wasn't
that
relevant.
there are portions of it that would be not germane, and there are portions of it that would be, right? So that's a thing. So the last question that I have for you is this. Well, no. Do you remember, so you said earlier that you disclosed when you suggested that Boardman and Clark replace Stafford as our village attorney back last February,
Mhm.
roughly?
Yeah.
Okay.
I was on the team that interviewed candidates for village attorney.
Okay.
And I forget, there was at least three. I think Carol was for that body. I'm trying to remember.
So I want to be really clear. I looked very hard for all the exculpatory evidence I could find. And that was a closed session. So I actually looked at that one, right? And that was a closed session, and it wasn't possible to see that anything. So at that, I would, do you mind if I ask your colleagues if they recall that disclosure? Because there's no record of it in any way, shape, or form. Carol, do you recall that?
I did not take part in interviews of the attorneys. Sorry. I didn't take part in interviews of the attorneys.
Okay. Did you?
I did not.
Shabnam, did you?
Believe I was present.
Yeah.
But I do not remember any disclosure of Boardman and Clark. I believe, John, you wanted Boardman and Clark as the village attorneys, but I do not remember a disclosure that you have a personal relationship with them.
For the record, I voted for Axel.
I don't remember that.
And from a purpose of like personal enrichment, that might matter, but for a purpose of a conflict of interest settling, bringing somebody to it, I don't know that it does, but
Yeah, objection.
yeah, right, nonetheless. You're right. All right, those are the end of my questions of Cross. Thanks, John.
Okay. The complainant has an opportunity to submit a closing statement.
Is there any further witnesses or evidence?
One question for trustee Letter. Sorry to call you out. We've never met before today, but your name did come up on the, is it relevant or not relevant, the profit loss data? Do you think reasonable minds could differ on the relevancy of that material?
Absolutely. I mean, my concern all along is that there was a good bit of time pressure with respect to this transaction. There was information that eventually would become available, like the appraisal, like the review of the construction of the building by an independent engineer, but all those things were going to be at the tail end of the process. So into that vacuum, you had these financial statements. And I have to say, these kind of statements, they're spreadsheets. That's all they are. They're not audited. They're not certified by the CFO. Anybody can make a spreadsheet. I understand the seller represented these reflected Logic's operations, but you have to take that with a grain of salt. So it greatly limits the utility of them. And frankly, I felt when they were disclosed, they should have indicated that this information was unaudited, that it was uncertified and so on. So the people understood it had limited utility and in fact could be misleading. So that was my concern. And that's why I and Bob Falk, as we worked on a report, did not issue any preliminary judgments. But it wasn't until the end of the process when in fact things like the appraisal became available that I felt an informed judgment could be made. So, yeah, I viewed them with a lot of skepticism. They may well be accurate, but there's nothing to prove that.
Thank you.
You're welcome.
All I have. Thank you.
Closing statement?
Yes.
Peter?
Good evening. It's turn it on.
Yeah.
It's on. It is, okay, thank you. All right, good evening, everyone. My name is Peter Hans. I'm one of the complainants. I'm a there are a lot of you know me, but there are people who don't, and there are people certainly viewing who don't. First of all, thank you for everyone who has been sitting here so patiently listening to the evidence and some arguments that have been made. Thank you for all that are viewing, all in the audience here. Thank you very much, Taylor, for such a great job trying to keep track of all this evidence. That was very, very difficult. Brian has been ill for the last few days, and he asked me to just make some closing remarks. They'll be brief because we've been here a long time, but I do want to open pit one. Again, I've been a village resident for about 65 years. I grew up in the village, moved away briefly, and then moved back in 1983. I initially joined the fire department, was a volunteer firefighter for 28 years. Eventually ended up getting involved in politics. I was elected as a trustee in 1999. Served as trustee until 2007. I was elected president of the village in 2001, served 3 terms, and then resigned. So thanks again. I want to just clarify something about section 1713 sub 2. It reads elected village officers, any elected village officer by a majority vote of all members of the village board because of continued physical inability to perform the duties of office or gross neglect of duty. So that's how you can remove a village officer. It says continued physical inability to perform the duties or gross neglect of duty. Now, the use of section 1713 sub 2 was discussed during a board meeting that occurred on November 24th, 2025. It was the first of the 2 meetings in which all 6 trustees asked John Imes to resign as president trustee. Shortly before 10 p.m. that evening, it's at the 1-hour point on the video of the meeting, the subject of removal for gross neglect of duty was raised by John Imes. The village attorney, Bill Cole, was present that night, and John asked Bill to advise the trustees regarding that statute and the use of the statute. Bill Cole stated that gross neglect of duty is not defined in the statutes, and there's not much guidance in the law.
Object.
Let him
Is
finish.
this a legal argument?
This is a
Closing remarks.
quasi judicial hearing. There's no rules of evidence
So
here.
is he representing the complainant as an attorney and practicing under his license? Is what
He's
is
giving a
happening?
closing statement. He's the
Yep.
complainant.
And a written intent, yes.
He did sign the.
He's, okay, so again, he said so these proceedings may involve what he described as quiet quitting. Somebody doesn't show up anymore, but also may involve financial misfeasance. But ultimately, the important thing he said is that it is up to the majority of the board to determine what is necessary to make the finding of gross neglect of duty. Of November 24th, The village's current attorney gave this board, the trustees, reason to believe section 1713(2) may be an appropriate remedy sanctioned by the state legislature for removal of John Imes as opposed to a recall election at a later date. John Imes was later asked to resign again by all 6 trustees, and he didn't. But this proceeding under 1713(2) is not a surprise, should not be considered a surprise. And it is appropriate to consider gross neglect of duty separate from inability to perform, that's at least according to Attorney Cole. You're all aware of logic. You're all aware that he had financial information. The argument is he didn't share it. Our position has been that John Imes had a duty to timely share all financial information, whether relevant or not, and it is up to you to decide whether he has been in gross neglect of that duty. As to potential conflicts of interest, Mr. Imes has testified this evening regarding that issue. And it's up to you to determine whether the record before you is sufficient to determine whether he has been in gross neglect of duty. As for the open record request, again, it's up to you to decide. But what I found significant, or at least most significant to me, was in response to the complaint, Mr. Imes could have, but did not produce all of the email messages that went to his personal email, this J. Imes email, that related to his government functions, his duties. And I don't think he produced any of that in response to the complaint. I didn't see anything in the exhibits that were attached. So was he in gross neglect of his duty to only use his official village email, or because he didn't produce copies of the private emails he may have received? That's for you to decide. John Imes argues in his response that the remedy set forth in 1713(2) means an opportunity for abuse is immense. Those are the words used. But twice he was asked to resign by all 6 trustees in open meetings for reasons that include those alleged in this complaint. This is hardly an instance where trustees are simply disagreeing with each other, not politically aligned, or do not like each other. The village's long-term stability depends on governance processes that include 1713 sub 2. The legislature has determined that requests for elected officials to resign and recall are not the only options. You do not need to agree on everything before you this evening. You just need to determine for yourselves whether John Imes has acted in gross neglect of duty. If you do so find, then you have a duty to this village to vote in favor of the removal. Thank you for your consideration.
Thank you. Attorney Deely, your closing statement, please.
Yes, and I know my client would like to read his statement as well. It doesn't touch on any of the legal issues, but I think it's important, and considering he's the accused, I would ask that he be given that opportunity to read his statement for attendance.
Sure.
Thank you. And then I will close on the legal issue there.
Well, thanks everyone for hanging out. I know it's been kind of a long night, particularly on the P&L stuff, but appreciate you being here. And I appreciate the opportunity to speak tonight regarding both the complaint itself and the broader concerns facing the village. At its core, the complaint raises important questions about governance, due process, and public trust. Removal of an elected official under Wisconsin law is an extraordinary action that requires verified evidence and a clear legal standard. As outlined in the formal response submitted by my attorney, which identifies significant procedural concerns, factual disputes, and legal deficiencies in the complaint, that removal standard has not been met. I'm not perfect, and as any local government official elected to a volunteer position knows, there are always operational and administrative challenges in the work that we do. But many of the allegations unfairly and cruelly attempt to convert operational and administrative challenges into accusations of intentional misconduct without evidence of concealment, destruction of records, bad faith, or intent to defraud. I want to be clear about these three things which have been alleged in the complaint, which are explained in depth in my formal response. I have never used my position with the village to gain a personal financial advantage for myself or my employer. I've never concealed public records. I've never intentionally given incorrect information to my colleagues or this community. I also briefly want to address the allegations related to the former Logic property. After extensive review and public discussion, the village ultimately decided not to move forward with the acquisition. That outcome reflects that the local government process worked as intended through public scrutiny, analysis, and deliberation. I am proud to have been part of that process. At the same time, I believe it is important to address the broader environment within village government. We have a lot of work to do to make things better for our colleagues, staff, and the community, and I do not think that removing me as president is the answer. For example, over the past year, the village has experienced significant staff turnover, declining morale, operational strain, and difficulty recruiting and retaining employees. Multiple resignation letters described hostility, intimidation, accusatory communications, excessive workloads, and the treatment of staff in meetings and emails. Former government officials have described threatening, degrading, and intimidating communications. The burden of open records requests alone became extraordinary for a village of our size. As our clerk treasurer, Taylor Wall noted, as of April 20th this year, Shorewood Hills has processed 35 open records requests, compared to 32 for the entire city of Madison. And a community 140 times larger than the village of Shorewood Hills, who actually has a full staff to provide those record custody. These are issues we need to address, and we need to recognize when the cumulative volume, tone, and frequency of requests and accusatory communications begins impairing staff's ability to perform essential public services. But instead, we are here. Well, there will be a decision on whether the votes of Shorewood Hills community members who filled in my name at the ballot box will still count. I don't think that's right. That is in no small part because I fear this process is predetermined. The original agenda for this meeting makes it clear that some members of the board fully planned on the removal petition succeeding and replacing me with someone else. That is evidenced by the fact that the original agenda seemed to lay out the many steps the board would take upon my removal, including appointing my replacement, committee appointments, and possible action on substantive matters. It was only recently that the agenda was amended to eliminate the impression that removal is a foregone conclusion. Removal authority should be exercised only with extraordinary care, verified evidence, procedural fairness, and broad public confidence in the legitimacy of the process. If the public is unhappy with an elected official, the ballot box is where the public is heard, whether through a general election or recall. That principle is fundamental. Regardless of political disagreements, I hope we can agree on several core principles. Staff deserve professionalism and respect. Residents deserve transparency and fairness, and disagreement should be resolved collegially, thoughtfully, and with full regard for the long-term interest, stability, and continued strength of the village as an independent community and governing body. This community has a long tradition of civic engagement and public service. I believe our residents want cooperation more than conflict, stability more than division, and solutions more than escalation. I am committed to those values and finding a path forward with my colleagues on the board. My hope is that we all can recommit ourselves to those values, rebuild trust, support staff, and move forward together in a way that strengthens the village we all care deeply about. I trust that my colleagues are prepared to do the right thing today and reject this request for removal. Thank you. Councilor?
Okay. So I think the most important thing I want to address is the language of 17.13. Language of 17.132 specifies, yes, there's an or, physical inability or failure to perform the duties or physical inability to perform the duties of office or gross neglect of duty. Absolutely not. But under Wisconsin statutory interpretation principles, those two clauses cannot be interpreted in isolation. The one has to inform the interpretation of the other. And there are other provisions throughout Chapter 17 that specify for other types of positions, you can remove for misconduct, for crimes and misdemeanors. The village statute does not say that. That's the second rule of statutory interpretation that applies here. 17.13 sub 2 applies to physical inability to perform the duties of office or gross neglect of duty, which should be interpreted like its predecessor phrase of abandoning one's post, refusing to perform the work, not a refusal to perform the work in the way that your colleagues like you to perform the work. And so, as stated in the beginning, there is recourse here. There is recall. There is not electing John again when it's time to vote again. It sounds like the complainant said that this is not a case of political infighting. And it is unique. And 6 members asked John to resign. And that's absolutely significant. And that is maybe not typical political infighting. But what we're talking about is 6 elected officials voting to oust the 7 and to nullify the votes of the people who voted for him. And I think this board should really pause to consider, especially in a state like we have, with municipal bodies that we have, with divided government we have, this being used as a playbook. I don't live in this community. I live in another community where the people that I typically vote for, their positions are usually the hard fought, and they're the standalone guy on that municipal body. And I can assure you that their colleagues would love nothing more than to kick them out. But you don't have the legal basis to do it here. It will be appealed. You're talking about nullifying the votes of the people who voted for John here. That's a really big deal, and it can only be done with physical inability or gross neglect of duty. And even assuming gross neglect of duty applied to the types of categories of behavior we're talking about here, the testimony today is that we have an email that was on village servers. It sounds like a legitimate disagreement over whether this data from September 4th was relevant. There's been no evidence of John or his employer obtaining any dishonest advantage, no evidence of personal financial gain, which are the standards for an ethics violation. It's not lining up dates and guessing that maybe there was some sort of advantage somewhere. There has been no proof of actual improper advantage, no evidence of quid pro quo, no evidence of destroyed records, no evidence of damaged records. It sounds like we have an imperfect elected official. There's a lot of them, and you all would like him to step away. I get it, but this isn't the way. This is not a legal and appropriate use of 1713.2. It will be very vulnerable to challenge, and I implore you to vote no. There's no legal basis here, not on these allegations, not on this lack of proof. Please vote to reject the removal petition. Thank you.
Just to quick remark in rebuttal. Five of you were present when attorney, do you want to cut me off?
Yeah, I'm
Okay.
very sorry.
Okay.
I apologize.
Okay.
I have to.
Sounds good. All right, thank you.
Okay, so this concludes the evidentiary component of the hearing. And the board will then go into deliberations. The board has a choice to deliberate in closed session or to do it publicly. I would encourage the board to deliberate publicly. I am one person with one vote, but I think that the situation asks for transparency, and to deliberate in closed session would allow conspiracy theories to go on and not truly heal this community. Again, I'm just one vote. Closed session gives trustees cover, but I think every trustee here is brave and has already put their name on a ballot. And I hope that they can say what they want to say to the public. And so that's my opinion. I will look around the room to see if there is a discussion regarding closed session or how other trustees feel. I'm going to go to Carol first.
I'm fine with doing it in open session.
I am as well.
Trustee Chick,
I'm okay with it.
Mr. Rocky Van Essen,
Fine.
and Ms. Kate Elswick. Okay, wonderful. Does there need to be a vote, or how does procedurally we just proceed? Okay. The next step is I was thinking that we could go through each of the charges to determine what the facts are, and then go through the charges to apply the facts to the law. I did very quickly write some instructions here. I would like to remind the board that the party presenting the charges bears the burden of proof, that the standard of proof in this proceeding is a preponderance of the evidence. That is, the evidence must demonstrate that it is more probable than not that the respondent committed the alleged gross neglect of duty. Each trustee is expected to contribute to deliberations in good faith, to state their views candidly, to listen respectfully to colleagues, and to remain open to persuasion by the evidence and the law. Deliberation is not debate for debate's sake. It is a collaborative search for the truth and a just outcome. Every trustee is expected to act without regard to political considerations, personal relationships, or any external pressures. So, I mean, I think the most organized manner would be to start with the first charge, see what facts are disputed. The second charge, what facts are disputed, and then the third, and then to apply the facts that we've determined to law. I am open to an alternative suggestion if people have any.
I have a question, Shabnam.
Yes.
It sounds like we're being presented with potentially conflicting or different definitions of what gross neglect of duty is. Can we either have that? I think we should have that conversation so that the board is on the same page about how we're defining that. We can do that at the end, but I just wanted to flag that at the beginning if that's helpful as we go through each of the charges.
I love this suggestion. I think it's a great idea. What is gross neglect of duty?
So when I looked it up, I went through.
I'm sorry, you're gonna have to speak up.
Oh, I'm sorry. So when I went through this and originally looked it up and then went and spoke to an attorney and then had subsequent discussions, it's my understanding that gross neglect of duty doesn't mean it's an individual event. It's something that damages or could damage the village, in this case, right? To put it in particulars. That was repeated and willful. So repeated and willful and severity, kind of all what goes into the gross neglect part. I certainly didn't hear, and then I genuinely mean this, I've not heard from anyone else the definition that was provided by John's attorney. So I would actually ask for, and to be fair, that included our village attorney. That when I discussed it with him, I actually, Bill Cole is one of the people whom I asked that question of, as I recall. So I was going to say we should ask, but I'm pretty sure that's one of the sources. So anyways, but that is my understanding is that, and that it's in this particular case, because it's being used in the quasi judicial thing, it is more likely than not in layman's terms, preponderance of evidence and legal.
Thank you, trustee Ochik. Is there another trustee that would like to comment on what they think the definition is? Carol, please.
So, as Attorney Deely has reminded us several times, the neglect is paired with physical inability. So it seems like a negative definition. You're not either not able or not doing what you're supposed to be doing. The job of being the village president. Whereas in the response, I read that crimes are only prosecuted by the state. And the way, and so meaning through the DA, through the Attorney General, or perhaps also through the Ethics Commission. So what we have here in the complaint is number one, perjury, number two, misconduct, and number three, concealment. So this is all new to me, and I'm not commenting on. I'm not retracting my requests for President Imes to resign, but I am wondering how we can take these active things, perjury, misconduct, and concealment, which are crimes that are supposed to be prosecuted by the state, and squish them into neglect, which is a negative, a not doing, whereas the crimes are doing. So this is my this is a question to everybody else, and this is my main concern about voting to approve removal, is that we'll be doing something that is not allowed.
So as one of the authors, I'm the only person that
You gotta raise hand, please, if you don't mind. Can you hold the thought? Go ahead. I want to go ahead. Just go ahead.
No, because I read Attorney Deely's response to, and I was surprised by the points. I thought I made it clear that I was categorizing them under those subheadings, but that I was clear that we weren't actually thinking we were trying him for a crime in any of those. We are making a decision about whether that was more likely than not in regards to gross neglect of duty with the specifics involved. So a DA potentially might, if they had perfect information, could try any one of those three things, but we don't use the same standard of judgment, nor the same, nor a jury, right? Nor the same standard of evidence due process. There's only a free job or an unpaid job that goes away. There isn't jail or other recourse sitting on the other side of that. So that standard of saying that in putting those under those subheadings, because I thought that was kind of where they fit in talking about each one of those was didn't meet the, or I thought met a gross neglect of duty. It was not to say that we had the ability to find him guilty of perjury, or we had the ability to find him guilty, or that we even needed to. It was simply categorizing the findings for whether they rose to misconduct in public office for gross neglect. Gross neglect is always the singular bar during authorship.
Carol.
So, thank you. So, regardless of the reason that you describe them that way, I think we still have to answer whether this is an appropriate way to deal with actions that are positive, you know, that were deeds, as opposed to neglect, as opposed to not doing.
So
I'm gonna look to Kate. Kate online, do you want to chime in on this?
Well, I appreciate the question, Carol. I think that someone can still be neglectful and still have action. I don't see it as non-action. Like me, I don't know if you're trying to read it like, oh, if John never responded to emails, didn't show up to board meetings, if that's how you're looking at neglect, it's the non-action. I think you can still be neglectful potentially with action, if that's what you're asking.
Rocky, can I turn to you?
I'm not a lawyer. This all seems like legal mumbo jumbo to me. It sounds to me like she tried to turn this into some kind of little factual thing. And I never did talk to Brian, and I didn't respond to her because I never communicated with anybody regarding this once I was elected. There's nothing to respond to. And the reason I talked to John is I wanted to see if John would resign before we went through any of this to save the village this turmoil, because the more I look into it, the more I see everything that's screwed up in the village, his name is on the end of it. We have a major budget program. He almost bought a building that would bankrupt the village. If we had that logic, we would be bankrupt. Period. He points people to drive to that CSA or the zoning thing over there. Does nothing. The guy lied to get it done, did all this stuff, and he keeps delaying and doing all this stuff. Well, I just didn't know. The whole thing back to logic again. Well, I just didn't know about the spreadsheet. Well, I'm not a freaking accountant. I wouldn't know to look for that. I'm not a lawyer, and I wouldn't know to look to ask who's in there and what's going to happen to that building. It's just neglect is someone capable of handling that position. And anybody looking at what's going on to this village right now and look where our budgets are going is we have a problem. We have a major problem, and the problem's right there. And when I see neglect, it's that he just doesn't have the skills anymore. Something might be wrong. I don't know what it is. My guess is he's very truthful. I don't even think he remembers things like he used to anymore. I don't know. I'm not a doctor, but I can use my eyes and see what's going on in the village. And to me, that's the gross neglect. That's why I never talked to Brian, because I didn't understand all this legal stuff, because I didn't think those really applied. I think what applied to is he's driving us right down the sewer. And I think the answer to that is yes. And I call that gross neglect. So there you go.
Thank you, Rocky. I will provide my input as well. I am an attorney. I did not find a definition to this phrase. I do disagree that the two phrases of the terms in statute have to be read together. My understanding is that you just read the plain language meaning of the statute. It's either physical inabilities or gross neglect of duty, but that the two have nothing to do with each other. So that's one thing. But what is the duty? I think that when I think about it, your very first primary duty is that you have an oath to uphold the Constitution. Both constitutions. You have an oath to uphold the statutes. And any actions taken that are contrary to the statutes are a violation of that oath. Maybe you're not in jail, but not being in jail is not the standard here. And yes, there are other avenues like contacting the Ethics Commission or filing a mandamus lawsuit to get your open records request fulfilled. But those options do not erase this board from having the power to hold this proceeding. Just because you can file mandamus actions doesn't mean that you can't bring this charge forward. Does that make sense? But the duty that I had was at the bare minimum to not be doing anything that is in the direction of unlawful, even if it is not technically, like, this is not a criminal court for perjury. It is just, we're here to decide on false statements, misrepresentation, not to apply the perjury statute the way a criminal court would.
I'd like to talk about the negative thing, if I could, for a second. So, and it's a great point, and it's a good question. Oh, then I just want to talk about the negative versus positive action for neglect for a second, because it's a good point, and we should think it through. So when I was putting it together, the thought on my part was why it fits neglect is that the theory that was investigated, and but again, what the evidence that I provided, at least I think, shows that John neglected to share financial information with all trustees equally. I mean, Charlie, you never saw that P&L, right? And you asked for it on multiple occasions, as did everybody else during that process. So the holding of information from other trustees while at the same time soliciting their vote, I think, is neglectful. Now, the other one about conflict of interest, John's compensation, I presume, is determined by the board. I guess we didn't actually ask that question, but it seems like a fair comment, or certainly some points of it must be involvement. It seems like, because he's the sole employee of it, it seems like that's something that should have been disclosed for anything that involved those three entities, which sat on this board. So that again is a negative action. It's a failure to disclose. It is a neglectful act. And as far as the records go, the one email address turned out to not be there, and the renew the blue one, I'm willing to give him that and say that looks like that's there. The email thing looks like that's there.
I'm gonna just,
yeah,
is it okay?
Yeah.
I really think that we could be here till 4 o'clock in the morning, and I would like to avoid that. I'm going to take a page out of Dietmar's book and try to wrap things up and force the conversation to continue. Do we have any questions or thoughts on the definition, the jurisdiction, the legal authority?
I assume that.
I'm
Attorneys
sorry,
are
but
not-
this is- that's
No.
correct.
I'm just confirming.
Sure.
Thank you.
Sure, you bet. I'm gonna say, Carol, are you satisfied? Slightly to proceed or no?
I am satisfied that I have heard responses. I mean,
What did you say?
what I mean is, I'm not convinced by what Brian and you have said. I've not changed my mind that. So what I read in the response and what I then went and looked in the statutes is that, concealing documents is a crime. Quid pro quo, if we were going to try to determine if that actually happened with John's business relationships, that's also a crime that then would be referred to the DA, and the removal would then be very different. It would not be under this 1713. So can we just take all of those and say, well, the watered down version of each of those is neglect? I don't know. I mean, to me, neglect sounds like you didn't do something. You didn't do something that you were supposed to do. So, and you just say, well, if it was really bad, you would refer it to the DA, but he was just supposed to put this in. So we can call it neglect and we'll do this under 1713.
Sure.
I'm not convinced.
And I would like to pull in the village attorney at any point if you would like to join in. I think that if there was a hypothetical where you have a trustee that is involved in embezzlement, you would be able to remove that trustee whether they're charged by the state or not. They're separate.
So say again, if a trustee was embezzling, that you could just remove them without
You would go through this process.
Right.
But just because the state has not charged or proceeded, that doesn't prevent the body from removing someone for that
Okay,
reason.
but in that case, the state would have had the DA investigate, correct?
They're separate. If the
Yeah, I
state
know,
doesn't,
I know,
they
but
don't have to.
We haven't had the DA investigate here. I mean, maybe it's preliminary actions in that we don't have the answer in order to then charge and proceed.
I'm also not in any shape or form at this in place and time trying to argue for one item or another. We're just trying to understand what the law is. And so the point I'm trying to make is, like with the records, you can file a mandamus lawsuit to get your records, or if they're concealed, the board can take action on that because the board feels that it is a gross neglect of duty. They were separate. And I don't know if I'm making my point clear. So Chris, do you want to add anything?
I feel like my role would be to respond to questions.
Okay.
That the trustees may have, but I don't want to opine.
Sure. So then do you have anything to add on what gross neglect of duty is or how you would approach that?
Well, I agree that it's a term that's undefined in statute. What we have is what 17.13 parent 2 states, and I just want to read it in its entirety. Any elected village officer by a majority vote of all the members of the village board because of continued physical inability to perform the duties of office or gross neglect of duty can be removed. So that's what the statute states. Gross neglect of duty is again undefined. As part of the interpretation of that, if we have a term that's undefined in statutes, we use common definitions of what those terms are. So I'll just read the definition of neglect. The first is to give little attention or respect to, disregard. Second is to leave undone or attended, especially through carelessness. Those are the definitions I see for the word. I think those are informative, but they're not binding in any way because we don't have a statutory definition. So again, it becomes incumbent upon the board to sort this out. I will say one thing though. There are specific allegations in the complaint, 3 of them. And I think due process requires that this discussion center around whether or not those 3 allegations rise to the level of gross neglect of duty. This isn't a question about whether or not Village President Imes is good or bad for the village. The question is whether or not the complainants have proven that he has grossly neglected his duty, and specifically whether he's grossly neglected his duty by one of the 3 allegations in the complaint. I think that those are the questions before the village.
Do any trustees have questions regarding the standard? Was that helpful for
No,
them?
I think it's 2 different ideas. This can be a legal thing, which is what I think Carol's talking about, or this can be a competence thing, which is what I'm talking about. And I think gross neglect can be competence. If we have someone who's not competent to hold that position, who continually makes decisions that send this village into a financial negative spiral, that's incompetence. And that's neglect of duty. If I was sitting in that chair, the president's chair, and I did anything he did, I would expect you guys to boot me off this board. To me, that's neglect.
Okay,
Okay, but the other stuff Carol's talking about, if we're gonna go legal, then I don't see the legal case. It looks like all mumble jumble to me, but I don't think that's what this is about. Because we could have got a stack that high of things John has done, but we pared it down just a few to keep it short.
so I want to emphasize that this is a quasi judicial proceeding. There are boundaries, and as Attorney Nelson has iterated, if you want to stick with competence, you can, but you've got to stick with the 3 charges. You cannot bring anything into this outside those 3 charges.
I know.
Okay. So on that note, could we go to charge 1? And I'm just going to ask, are there facts that, how do the trustees feel about the facts as they're related to perjury, misrepresentation, false statements to a legislative body? This charge predominantly appears to deal with the profit and loss statement. So we're gonna spend 5 minutes and talk about profit and loss statements made. Does anybody want to go first?
Well, I can say something.
Rocky.
Everybody says that, the information was there for the getting. But I seem to remember, the resident Marilyn Townsend first brought it up and Gary up. And I seem to remember, I think on 2 or 3 different times running around the village trying to get stuff. And I remember we couldn't find anything up from the board. Everything from the board, we had to get out with a freaking crowbar. And that's where the requests came in and all that stuff. So to me, they're hiding everything about that building. It's like the building was predetermined. And you guys say it wasn't, but I remember going through this whole village. I spent a lot of hours putting around Maryland's flyers, which I happen to agree with. And it wasn't this 5-2 vote. As soon as Carol flipped her vote, then John flipped. We had 3 solid against it. Carol flipped her vote, then John flipped. That's what happened there. That thing was right down to the bloody wire. And if Carol hadn't flipped her vote, we would now own that nutty building over there. And to me, that shows that P&L not showing us was important. Had that P&L been out, you don't think Marilyn would have flown that P&L around the whole village the day she had it? I mean, come on. If I wanted to get the logic building, this way, if I want to do that, I would hide the P&L statement. And to me, I would do exactly what I saw John doing. If my goal was to buy the logic building for the building, that's how I would do it. All right, and to me, that is negligent. So I think on that one, he's guilty.
Can I ask Rocky a question?
Sure you can.
Rocky, so your last point, just to make sure that I'm following the way that you state things sometimes.
I'm sorry, could you speak up?
Oh, I'm sorry. The last thing that you said during the last comment, just good.
Any longer.
So it seemed a minute ago that what you were implying was a lack of competence that was not, that actually, rather than following neglect, was an inability to function almost. And I'm wondering, with comments like looking at a projected number and that had zeros on it and having assumed it was real, and then quoting it out to the village, and then not noticing the numbers right underneath it were negative, that you're raising a mental competency objection there to that point. Was that where you were
Well,
going?
I'm not a doctor, but I think a high schooler could look and see those numbers. And that building was empty for 4 years. Come on. But I'm not a doctor, but that's my impression.
I want the trustees to pause for a second. While this statute has 2 parts to it, the only part that has been provided is neglect of duty. And maybe I should clarify.
So the spreadsheet I thought we were talking about the spreadsheet.
Right.
Right? So I simply do not believe that he didn't know about that spreadsheet several months before the building. It makes no sense to me that they didn't know because of the way they were behaving. And the firefight to get that building up here was huge. We had a whole ton of people trying to get the board to slow down and look at this thing. I simply do not believe what he's saying. I don't. And then it shows up miraculously the day before the vote. The actual spreadsheet does. I think he had it all along. No, I can't prove it. You know, so I don't know, but again, we're saying it's like competence. It's like he should have known. If he's the president of the village, he should have known. I'm sorry. If I behave like that and the village didn't kick me out, well, that's shame on them.
Carol?
So I have a different tack maybe for looking at charge 1, which is perjury, misrepresentation, and false statements to a legislative body. In the response to the complaint, Attorney Daly outlines the 5 elements of perjury. And the first one being that the person would have to be under oath. So, you know, that is the standard. It's a crime, right? And we apparently are going to be evaluating it under a different standard, gross neglect, which we don't know what the standard is. I guess I have a question, and perhaps this is for Chris. I'm not sure if you can answer this or not, but if John were voted to be removed and this would be appealed, would that be evaluated under, might the court evaluate the appeal under the criminal definition of perjury, or would what standard would be operating there in the appeal?
I think the board can expect it to be operating under the standard that's found in the statute, which is Wisconsin statute 946.31. And the reason for that is because it's specifically alleged in the complaint that statute was violated. Therefore, I think it is part of the record and it will be evaluated as such on appeal.
I mean, I think I have a slightly different take. I think an issue on appeal is whether a reasonable person or a reasonable body would have reached that reasonable conclusion is the standard.
The standard on appeal, if a decision, either way, in this case, were appealed to a circuit court, there would be 4 things that are reviewed. Number 1, does the village board have jurisdiction? Did it act within its jurisdiction? Second thing is, did the village board proceed according to an incorrect theory of law? The third standard is whether or not the village board acted in an arbitrary, oppressive, or unreasonable manner that represented its will and not its judgment. And the fourth standard was the order or determination made by the village reasonable based on the evidence. So if this were to be appealed, it would be appealed on what's called the certiorari standard. And those are the 4 things that a circuit court would look at on certiorari review. So that's the standard for appeal. I can answer any questions about what those specifically are, but that would be the appellate standard.
Can I also clarify? So the charging document says perjury, misrepresentation, or false statements. It references the statute 946.31. And then at the end of this charge, it says whether these statements made before a legislative body constitute perjury or false statements is a matter for the board to determine. So what happens when the charging document gives an idea of what the charge is and references a statute, but it's not bringing this under a statute? It doesn't have authority to bring it under statute. You are just supposed to describe the charges in a way that is understandable. There is no statute for dishonesty. There's no statute for misrepresentation. So you are just describing the behavior. It is not required that a statutory citation be provided.
Well, and I appreciate the interpretation. The question was whether or not this would be subject to review on appeal. And the answer is yes, it would be, because it's in the complaint.
So let me get this right.
So the board would either, yes,
Just so you know, Mr. Ilstick.
Yes. Kate, your turn, you go next. But let me just say one thing real quick.
Yeah.
So you could do the if the board were to charge perjury, you would need to have all the elements, is what you're saying.
Well, the board didn't bring the charges. The board's in receipt of a complaint and reviewing the complaint and making findings based on the complaint, and ultimately will issue an order in this case. The complaint specifically references that it references the perjury statute. It states perjury, misrepresentations, and or false statements to a legislative body. And it goes on to state facts it believes supports those. The question is whether or not a reviewing court would look at the perjury statute as part of its review of the record on appeal. And I would submit to the board that it will, because it's in the charging document.
I'm going to go to Kate.
It's okay if Brian wants to respond,
So,
if it's on topic.
I mean, this would be a terrible time to learn that I play lawyer off.
I'm sorry, can't hear
But, no, sorry. So, I'm not an attorney, right? And there were attorneys that did look at this, but the board exercised its authority under Wisconsin statute 1713-2 to determine warrants removal of office for gross neglect of duty. Literally, the opening paragraph of this document says that we're not prosecuting the other things. The title of the document, 17 John I'm 1713-2, that was emailed out. It is not the legal framework underneath those subheadings were only included as a way to group them and a way to think about them in things that I perceived shouldn't happen. Right? So it would be very upsetting to see that all taken literally when the first sentence is that Peter and I put in here. We're hereby submit this formal complaint against Village Archives and request the village board exercise authority under 1713-2 to determine whether President Eisenhower warrants removed from office from gross neglect of duty. It's very clear, in my opinion, what I was saying. Now, if because the other portions are there, and the appellate court would look at it differently, I have no idea. But that's surprising.
I'm going to go to Kate.
Yeah, just to bring it back to the facts that we heard earlier around charge A. So I think there was a detailed discussion between people in the room about the detailed P&L versus the non-detailed P&L being shared. But I think that what we missed kind of in that conversation was that whether it was detailed or not detailed, a P&L document was not shared, is my understanding. So I think I just wanted to align with the board on that fact. Is that what we're all understanding, that whether it's detailed or not, a P&L document was not shared with every single trustee?
Is that a fact that the trustees agree on?
I don't think the trustees will know as a practical matter because of the fact that the P&L may have been directed to an individual as the two-party on that email send, but it could have been sent blind copies. So I may get an email, says it was addressed to me, but I have no idea who else may have gotten that email, right? Because if it was blind copied, who knows where it goes? I don't think any trustee can say exactly where every email went.
John said he only sent it to you and Bob. Because he didn't want to violate open meetings.
Yes. He said that. So you got it.
Okay.
And you knew we were all looking for it. Yeah,
I
you
didn't
did.
know you were all
Oh,
looking
come
for it.
on.
I
All
assumed.
right, all right, never mind, sorry.
I'm looking, okay. Okay.
Okay,
I think
so
we
it-
just- I think
Kate
we-
has the floor. Go ahead, Kate. And then Mark, go next.
Well, yeah, I wanted us to just understand if that is where we're all at. It does sound like John admitted to that tonight. So I think that we should take that into account when we decide on this one, because whether that was material or not, it was critical financial information for a purchase of a major built like a earth-shattering building when you look at especially even the percentage of the budget that the village operates, and especially when that purchase was being positioned as a revenue positive purchase. So I just think if we agree that some information was withheld from some members of the board, I think that is an important fact base to look at charge A on.
Mark, did you want to add anything?
Well, I just think we want to be very careful here. Gross neglect is a high bar. I'm talking about simple neglect here. And we're not talking about mistakes that anybody can make, oversights. I think as a board, we've all expressed our concern, our frustration in the last couple years, and in particular last year, with the extraordinary set of circumstances that went on. A village has never gone out to buy a building like this. It was pretty much unprecedented. And I think we want to be very cognizant when we think about the mistakes that were made, okay, the errors that were made, whether those errors can be explained by the extraordinary circumstances that we were going under. And we don't try to take, errors that anybody can make and all of a sudden elevate them to gross neglect so that we can accomplish a particular end. I mean, we've all said we would prefer there be a change in leadership. We've all expressed a desire for John to resign, but you can't just accomplish that end by any means that suits you. It's a narrow path that's before us, and that path is gross neglect of duty. And so I think as we review these charges, you can't just take each one. There's that particular charge, that wasn't just a mistake. That was a gross mistake. That was a repeated mistake. That was a willful mistake. I mean, the one piece of advice we got the other day from the League of Wisconsin Municipalities was to slow down. Okay. I don't see us doing that, and I really urge the board to go slowly now, because this is consequential, not only personally for John, but also for the village and for all those people that cast their votes in favor of John, and they have no say in this. And I understand that's what the statute provides, but if that doesn't make you a little bit uncomfortable, I'm not sure that you're a small D Democrat. It's something that we really just need to be very careful about, because the actions we take tonight don't end tonight. The board's decision will not necessarily be a final decision. So we will have to own the consequences of that. So let's be really careful here. That's all I have to say at this point.
Thank you, Mark. I am gonna call on Rocky. I do want to emphasize that your job is to apply the evidence in the law and to not consider outside external pressures. And I'm hoping to get the board through an exercise. Some people might have already made up their minds. I prefer that we don't do that. We're just going to go through the facts, and then the facts could read one thing and the outcome could be something else. But I think it's important to go through this step by step to the best of our ability. Rocky.
Just tell me one thing and then I'm gonna make a motion. All right?
No, no.
Why not? Why can't I make a motion? I can make a motion anytime I want.
Okay.
This is the one comment I got. This has got to be the most incompetent person I've ever sat next to. He's almost bankrupted the village. But in this type of proceeding, I don't think we should go any further with it because now it's turned into a whole legal thing. And I think it's going to cause a freaking war in the village. Because the people who want John gone are going to say we did the right thing. The people who don't want John gone are say that we went and nitpicked him. So I'm making a motion that we end the meeting and don't act on the removal. Just need a second.
I was hoping
Second it?
we would go through an exercise.
Well, I don't think we have to. So I made a motion that we just end the meeting. We don't act on the removal.
So Taylor, we have the motion. Is there a motion on the,
I just made it.
okay? Taylor, could you just repeat them?
The motion is to end the meeting and not to act on the removal.
Well, I'll second the motion.
Would advise the village board that the motion is made, they're not gonna resolve the issue. It's just an ending of the meeting. It does not address the complaint in any way. If the motion was to dismiss the complaint, that would be something different, but this motion does not address the complaint itself in any way.
If we stop, then we stop. I think the complaint's valid. I just don't want, I think we should just stop this proceeding because it's gonna cause a war. And quite frankly, I don't want to have a war in the village.
If the board wanted to vote to not remove, I think that's a decision it can make. I still think that it's necessary to provide a written decision with the facts.
I don't think it is at all. I think we can take a motion and we can end the meeting. I put the motion out there and mark a second.
Okay, so I'm gonna
So we
call
can have a
vote
discussion.
unless
Well,
there's more
there's a
discussion.
discussion, isn't there?
Sure.
So what I will say is this. I think we should finish discussing our points. We didn't even get, we only got.
Sorry, I can't.
Oh, I'm sorry. I think we should just finish discussing out the points. We've only discussed A right there. And I think with Kate, there's general consensus with the exception of Mark, that it looked like that data was not there. And as you pointed out, it could have had significant financial ramifications for the village. Enough that it potentially could have bankrupted the village. I think that's not an overcharacterization. But here it is a conjecture. But the thing about this is we're only supposed to consider based on what's here. I know people have sent us a bunch of emails and texts, but our job, this is like a court, right? We're supposed to think about just the thing in front of us. We're not supposed to consider all the other factors.
All right, so this is discussion, right?
It is.
So if we're looking at things in front of us, I think there could be an argument made both ways. You know, she spoke and she couldn't shut up long enough, but you know, she's right about a lot of things that you could argue both sides of this fence. And so the question is, in my opinion, we got a year of this guy, all right? We can throttle him in other ways in the board. We can make the power, like I've always said, we should make the board into a body where the president is just another voting member. We make the board act that way. We try to get committees going. We try to strengthen our committees. And I just think our time is better spent doing that than this. And I'm telling you right now, if you had the motion to remove, I'd remove them, all right? But I don't think it's worth the heartache it's gonna cause in this village. I just don't see it. I don't think it's worth the tension and the turmoil, and that's why I put up the motion that we just stop. We don't have to have a conclusion, because personally, I think he's guilty, or whatever you call it, I don't know what the legal term is, but I don't think it's worth the infighting. People did vote for him. He got the job. There's other ways we can protect the village financially in the next year, and I think we should pursue those.
All right.
There, that's my.
So, in the interest of time, we could find a way to speed this up. If people also need a break, just let me know. But a signal from everybody that we want to move a lot faster. Is that right? Okay.
Kate's got her hand up.
Kate.
Sorry, I'm having trouble unmuting. There is a motion on the table and it's been seconded. So do we need to call a vote on that, or are we going to just agree to keep discussing? I think there could be a lot of merit to slowing down. We have the evidence, and if we pause the meeting now, we can continue this discussion. So I just wanted to throw that out there. I know it's late, and now that we have things presented, we can continue the discussion at a later date.
That's true.
Yeah.
Yeah.
Yes, I think we could do a motion to suspend to a date certain, where the hearing would be continued at that point. I would ask if there was any.
It would be over objection. We asked for a continuance. I'm sorry.
It would be over.
It would be over objection. We asked for a.
Why is she talking? Does she have a voice?
Or if I had a position on
All right, I
the
misunderstood.
objections.
But yes, okay, so I think you could do that if the board desired to.
So I thought that's what my motion was doing. If we just stop tonight, isn't that what we're doing?
That was not my understanding of your motion.
My motion was we don't act on this, we just end the meeting. Which in effect would not remove John Imes tonight.
So that I would take that as a motion to adjourn, which is not debatable.
All right, Mark.
Yes, just a question for you, Chris. If this motion passed, if the board approved it, would the board be under any obligation to further respond to the complaint?
At this point,
Is it indefinite? Is there a timeline? Are we required, or can it just be? I don't know. Where does it go from there?
yes. No, I think the evidence is in. The parties have submitted their evidence. So I don't think there would be an opportunity to further address it. I will say what the statute says with regard to this. This is Wisconsin Statute 17.16, parent 3. And it states that there needs to be a speedy public hearing, not further defined. What a speedy public hearing is. Well, we've had a public hearing, and you can come back for further delivery if you so choose. It's again not my understanding of that being what the motion was.
So the board is not obligated, assuming this motion passed, the board is not obligated to revisit this issue, to revisit the complaint,
Well, I mean, what do you mean by revisit the complaint?
to bring it back to the board.
Does it have to absolutely be on another board agenda? Perhaps not. But that being said, if it hangs out there for a period of time, issues could arise.
I would like to ask, in the interest of time, that every trustee just go around and summarize any findings or opinions they have on all the documents presented and the testimony taken today, so we can speed this up.
Just call the question. Call the motion.
I can also do that, correct? I feel I would like to say more, but Carol.
I mean, we are under an obligation to provide a speedy hearing. We have Chris here, we have Aaron here, we got everybody together, special meeting, scheduling, we're here. I think it's incumbent on us to see this through to a vote on the issue at hand.
So I'm going to call the vote. I'm not going to support it because I think we can finish within 30 minutes. And that would be a more complete finish than in the middle of it where it's not complete. All in favor of Rocky's motion?
Can I ask it to be a roll call vote, please?
Let's restate the motion as well, please.
All right, so I have the motion as to end the meeting and not act on the removal of President Hines.
I'd like to request a roll call vote on the motion.
Okay, go ahead.
Barford,
No,
Butterer,
Sorry, can you repeat the motion one more time?
the motion is to end the meeting and not act on the removal of President Hines.
Yes.
Lotfi,
No.
Olsvik,
Yes.
Goodshake,
No. So what happens when it's 3-3?
Van Aston,
Oh,
I'm gonna say yes. I don't know what we do with the ties.
Yes.
You want to adjourn?
wait.
Read the motion again.
The motion is to end the meeting and not
John's not
act
part of the
on the
deliberation.
removal of President Hines.
Not,
Yeah, it doesn't get to.
Do you want them to proceed to continue to deliberate, or do you want them to table it?
I think we could finish this in 30 minutes.
I'll say no.
I'm going to give every trustee one opportunity. Please wrap it up quickly if you can.
Motion fails 3-4 by the way.
I guess I'll go first unless somebody else wants to. On the first charge regarding perjury, misrepresentation, and or false statements to a legislative body, I heard John's testimony today that he had the P&L. It was sent to him in a link. When I remembered that link and clicked on it, it did not require a download. It was just opened into a Google sheet. John, that he shared it with 2 trustees and not other trustees because of open meeting violations. However, in Exhibit 25 of the appendix, which is Exhibit number 2, in an email, John writes that all the materials received were accessible to all the trustees. And so I find that statement to be false. In the statement made to the Cap Times that all trustees had relevant information, I find that statement to be false because as of today, John has stated he only shared it with 2 trustees, did not violate open meeting laws. Other false statements. One second. I mean, there's an email chain and it repeatedly says that neither Brian nor I withheld the information. I will continue to this second charge of misconduct in public office, failure to disclose conflicts of interest of the recused.
I'd like to ask Chris one question before we go on to the next item. Chris, it was my understanding that as trustees, we swear an oath, we keep getting it, but during board meetings, are we not operating under oath? It was my understanding that according to Wisconsin law, that we were. We make statements to the public. We're expected to be making truthful statements during board meetings. I was under the impression that that was during board meetings or during these functions, those statements are under, oath, is my understanding. Is that wrong?
No, I don't believe they're under oath. I think in order to be under oath, you need to be sworn in and affirm that everything you say is true and accurate. I don't think you can have a statement under oath without actually taking it.
Okay, so the oath that we take when we take office, does that count for that during these meetings? Is that just perpetually in effect, in perpetuity in effect, if you will? All right, never mind. I'm just curious because if the
Sure.
question about oath is a thing that people want to answer, I just wonder.
I think that I don't need to be sworn in to tell the truth. That I should tell the truth as a trustee all the time, regardless of whether I'm sworn in or not. I read the answer and the affidavit regarding conflicts of interest. And I found it interesting that Stonehouse Development was not listed. And it made me question whether that was a concession of a conflict of interest because there was no mention of it in the
Absolutely not.
answer.
Absolutely.
I think, okay, sure. I understand that maybe there is no conflict in the sense that there was no financial gain, but I still believe that when there is an appearance of a conflict, whether there's no technical proving of financial gain, it's warranted to disclose it. I can't imagine receiving money from Centro Hispano to fight immigration cases and then coming to this board and asking them to pay them for membership. Like, I think that it's appropriate to reveal and disclose when there's a conflict of interest. And it does not require a financial gain. I think financial gain is not, you could feel a need to reciprocate a benefit. If somebody gave me $10,000 for my business, I could feel a need to help them, which would impact my obligations to the residents. And I think that John should have mentioned his relationship with these organizations. There's not enough information, in my opinion, to find it's more likely than not that this was gross neglect of duty. I don't think it's gross neglect of duty. I think it's neglect, but absent additional information, absent more documents in these exhibits, I don't know if it rises above that 51% standard. On the last issue of concealing public records, I do not believe John when he says that he chose to respond to Ava because he gave her his business card that had a Gmail address on it. If I look at all my emails over the last 6 months, the vast majority of them come from jimesother@gmail.com and copying himself. So to say that Ava happened to email him to his Gmail account, I don't believe it. Every email I get from John is personal email copying himself. I don't see that being true of any other trustee or any other business that I interact with. I do not get an email from a Gmail account from my pediatrician who copies UW Hospital. I do not get an email from a first grade school teacher at Shorewood Elementary School who sends it from a Gmail account and then copies the school district. I believe that that action doesn't have an explanation except evading public records. The process for public records is they search from the account that your inbox, like they would search slutfi@shorewoodhills.gov. They would not know to put my email in a copy unless the requester requested that. And so I do believe it is to evade public records. I believe that it is terrible in the evidence how many email exchanges there were in it's exhibit 24-25, where we were asking for this document. And how many times John said, you have it, when we didn't. And that gaslighting was awful. It doesn't matter whether it was the exact same P&L or a different P&L. You had a duty to provide it to all the trustees. And you're hiding behind the difference between these two P&Ls to explain away the lack of sharing. I don't believe the president or any trustee should be involved in gatekeeping. I think your job is to facilitate and share. I don't think it's, I think I do believe that the third charge in combination with the first might rise to the level of gross neglect of duty because it is causing a fire. Every time John emails from his private email account, somebody catches it, an open record request is made, and then Taylor has, by law, is required to answer it. And that is causing the staff fire and the in and out of staff. Because we are at a point with you, John, that we are legislating to get you to comply with what every other person complies with. That is how much effort this board goes through to get you to comply. We are not having discussions on democracy. We're having discussions on governance and fairness. And you're refusing, repeatedly refusing. I don't think it's fair to Gloria. I don't think it's fair to any of the residents whose open records are not answered. I think I'm going to just look at my notes because I don't want to have to speak again. So I'm going to say that gross means willful and malicious. There's no evidence that this is an extremely rare undertaking just because there's limited case law. There's no evidence anywhere that other municipalities have not done this. I'm going to just look at one more thing and then I'm going to hand this over. So my final thoughts on this when I try to sit still and just get rid of all the noise is that I do not believe John Imes acts in the best interest of the village. I do believe that he acts in his own interest. If he acted in the best interest of the village, he should have had the detailed P&L from the very beginning. If he acted in the best interest of the village, he would have immediately shared any version of the P&L he had with all trustees. If he acted in the best interest of the village, he wouldn't repeatedly email from his Gmail account, which continues to fuel the open records request. I don't believe for a second that he thought that everything was okay if he copies the village. As I said, there's nowhere else in society that does this. I believe that John's actions are nefarious. I think it's brazen. And I think it's absolutely insulting when he says that it is your responsibility to ask me for the documents you want, and then I'll give them to you. That's selective disclosure. So I would vote for removal for the reasons that I stated. Next trustee.
Excuse me. May I just say for the record?
No,
No.
Yeah, I
No,
know.
you
No.
we can't.
this could have been closed.
Yeah. If there's another trustee that wants to go next, I will call on that trustee.
Chris, is that?
Yeah, it's
Rocky.
deliberations.
I agree with what the motion I did before because I do think it's going to tear it apart. But I do agree with almost exactly what Shabnam said. She said it better than I ever could. Because I can't speak in that language. But if I could, that's what I would have said. So I agree with Shabnam.
Gates?
Carol.
Oh, Carol?
Either way. I'm happy to go. I am still struggling to find the standard here of what of gross neglect. We've heard that for criminal considerations, you have to show quid pro quo, you have to show an intent to harm, you have to show that that actions were willful or malicious or had intent to injure or harm. So I think we pretty much, I think we are all aware of a common understanding of John's actions. For me, the question is, does it rise to the standard of gross neglect? And while everyone in the village who's been attending to these events has become very frustrated with John's actions, you know, the prevarication and the repeated refusal to come clean, you know, to show what files he had and when and where the email list came from, and et cetera, et cetera. I feel like this was not done on purpose to injure or harm, but to cover for his mistakes, to hide his incompetence. So, you know, again, I'm just trying to think about the judge in appeal. Will they take the frustration into account? Will they take the sort of cumulative effect of all this that we feel? Would that hold up in court? Because I don't want to remove John if it's going to be worse for the village. I mean, as a result of the further actions that could take place, my job, as I see it, is to do what's best for the village. So, as I've brought actions to the board twice, together with Dietmar, asking John to resign. And politically, I thought that was absolutely what should have happened. Legally, I am not on sure footing. I'm not an attorney. I don't have experience here. But my suspicion is that judge in appeal is not going to feel the same way we feel, having been part of this saga for months, and is going to be, I suspect, have a much clearer idea of what in his or her mind is the standard, and that it's going to be higher, than what we're talking about.
You fear appeal.
I certainly do.
Okay, so,
You are to not, well, I think you're supposed to vote your conscience.
Well, that's so hard. That's hard when, as Rocky said, we're worried about what happens after. I'm supposed to vote my conscience.
On what's in front of us.
On what's in front of us and not knowing the standard, I have to decide on one. I have to make one up for myself. Gross neglect. I am a pretty literal person. To me, neglect means not doing. So did he grossly neglect his job as president? In total, I would say no. He's been acting as president. He's not absent. He's not, but he did do some things wrong. And what's the right way to address that? The things, yeah. I don't think that this is the right way to address that. And I also want to give a lot of thanks to the people who have been pursuing this the most. Brian, Peter Hans, and others have done a great deal of work to uncover, Shabnam, to uncover the P&L and to bring truth to light. I don't mean to belittle any of that. I'm just struggling with the standard, and that's where I am.
Who's the next trustee to get called on?
Kate, you want to go next or you want to wait?
I can go. Honestly, I don't know if this is possible, but I feel like I agree with Shabnam, Rocky, and Carol. So for me, I'm also looking at what was presented only this evening. Did that rise to a level of gross neglect of duty, not knowing exactly where that line is and where it's, it is a little, you can interpret that how you want. I also see multiple things that have gone wrong here over the last year that I've been involved in village politics. I think with the P&L, this was not just a mess up on one email. There was repeated moments, both in person and virtually, where this information could have been shared. And again, it's not just a side piece of information. I totally respect that the P&L was for a different business model, but I would also like the respect that I, as a trustee, could interpret that and that I could take that into account in my deliberations. I was not given that chance. And the fact that the logic vote didn't happen was in spite of this. That is not a proof point to prove that this was okay to do last fall. We had to fight through that to get to that decision, to get to some of the truth behind financially what that impact would have on the village. And so there were multiple instances there that John could have corrected that. And I do feel like that was way out of line and not acting in good faith for the village, and truly could have been a monumental error financially for us. So, I mean, to me, that alone is a major thing. With the conflict of interest, yes, we're not seeing tonight a quid pro quo. However, what I am seeing is, why not recuse? What's the downside? There is no downside. It seems and feels a lot more suspicious to not recuse and to not call it out. If you have nothing to hide, if there was no financial, no connection to a nonprofit or anything like that, then why not call it out? That's where I'm kind of confused on that. And again, as Brian has stated, that was repeated. These are 4 examples tonight we're looking at. There could be more, I don't know. But that's 4 very different times that happened over the last 5 to 7 years. And in terms of the open records requests, again, I think there have been repeated asks to have John email from his .gov account. I do not know why that hasn't been switched. It's a very simple matter of respect, and it's something that all of us do on the board as well. So I do feel like that would be a very simple thing to shift and would really, relieve a lot of headaches. And so, I do find malfeasance with all of these. And I'm also trying to judge where my line is. As with the other trustees on the previous board, we all have asked John to resign twice. And tonight I am leaning towards removal.
Well, I thought I already said my piece, but I do not believe that the evidence presented tonight meets the very high bar of gross neglect of duty. That's the bottom line for me.
I promised 30 minutes. I'm trying my
Brian's the only one.
fastest to get everybody out of here.
So. Yeah, I did learn some things tonight, like to renew the blue one. I think it's
Can you
the,
use your microphone?
oh, sorry. Yeah. I did learn some things here tonight, like for the renew the blue one, I would say it's 3 things, not 4 things in the COI, that portion that leave me still concerned, Kate. Purely your read, about, not wholly neglectful is very true. That's a true statement. I don't see wholly neglectful included in there, or neglectful in every way. But that caught me off guard. I don't know if that's the way that's supposed to be interpreted. I think so. But that was an interesting read. Regarding the profit and loss, it does appear to me that that was willfully withheld, admittedly withheld, and that could have had real consequences. And does that rise to gross neglected duty? So here's the way I think about that. Let's say we're talking about the 6 acres that Flad wants to develop, for example, just as an example, because it recently came up with the sale of Village Hall building, between a new building over there, right? We're building out on that lot. When that time comes, how does this board function? So I would say that it's difficult for us to function with John at the head of that, because he was neglectful enough in the duty the last time that it's going to make the open records requests continue, right? And then that cycle has to end somehow. And I think those are related. But I think that burden is, I think that one hits the evidentiary mark for gross neglect, just because it persisted for so long, and could be so damaging. And I think it's impossible for government to function without transparency among peers in critical documents for decision making. As far as charge 2 goes on the COI, I think that the MGE and the Bourbon and Clark in particular, because of the fact that that documented, and it was not refuted, that he had not recused in those instances that were there. And those folks are, those are his bosses, for lack of effect, he's the sole employee at that nonprofit. I don't see how that cannot be something that would have been brought up. It seems to me that that would be a mandatory thing, not an elective one. The Stonehouse one, I actually think is more concerning potentially ethically, but to be fair, nobody tried to prove financial malfeasance here. We don't have access to his books. There's no way to be able to validate that. There's just the fact that he's cutting ribbons with them on another place at another time for the same building. It's possible there were no financial ties. I don't know if that triangle connects either, where like it's paid by another party, where they certified where they did the building. If that's a nexus of operation that would normally qualify under law. Not being an attorney, I don't know the answer to that. But I think that the charge on the first 2 is solid enough that I would tend to think that voting to remove is the only thing that could be there, because if we can't trust people to disclose major conflicts of interest that they have, right? I mean, yeah, the next developer to build the next kid zone could be Mark's uncle, right? Or brother-in-law or something like. And if he didn't recuse, that would, I imagine folks would rightly erupt. In this case, that's what we're dealing with here. We tried to suggest Boardman and, anyways. So on the third charge, the open records request, some of the, like the one email address is not there. Actually, that's the one that I might not vote to convict on. Or not convict, but vote yes on. But I don't know that they all have to be the same. I don't know they have to be, that we have to be uniform in that. So, so right now I'm leaning vote to remove. Because I think those other two were, I mean, the evidence shows that those things happened. Right. And if I'm concerned about what happens in the village too, outside of this. Everybody emailed me as well. But we're not supposed to take that into account here. We're just supposed to take into account what it says, and is that the case? And if you ask me if I think the village can function with those two things happening, I don't think it can.
Yeah, motion, we have a motion.
Anybody else want to add anything? I guess I kind of want to add something. I really don't like the idea of removal being a split vote.
I'm sorry, you don't like the idea of.
I'm sorry, I really don't like the idea of removal being a split vote. I don't like the optics of it.
Well, it's all right. Let's just call a motion. You have. It is what it is. We don't have to all agree.
That's true. I'm not supposed to consider outside things.
Brian, want to make the motion?
Give me a second to formulate it, unless you want it.
No lawyer, I'm not a formulator. But this is what I'd say if I could. Say it right. I absolutely did feel right. And John, this breaks my heart. You gotta know that. But this is gross neglect. He is not, we cannot trust him to get out of this financial mess. So I'm going to make the motion that we, go forward with removal of President John Hines from office. That's said, right? It's not someone correct me.
Is there a second?
I'll second it just so that we.
Oh. Roll call vote. Is that how this works? We did actually end at a deliberation, did we?
It's called.
I'm calling the vote.
Barford,
I vote no.
Lutterer.
Read back the motion, please.
The motion is to go forward with removal of President John Imes from office.
No.
Lotford,
Yes.
Alsvik,
Yes.
Butchig,
Yes.
Van Aston,
I tried, Tom. I tried. I tried. Yes.
Imes,
No.
Motion carries 4-3.
Yeah.
Motion to adjourn?
So for,
No? Or
there's
something?
a written statement is required. It can be done now, and if everybody wants to get out of here, I can coordinate with Attorney Nelson, to provide that process.
I have something drafted that I could read to the trustees if they wanted to just extend for 5 minutes. This for your consideration, but it's entirely up to you.
I'll stay with 5 minutes.
I'll stay.
And I'm basing this on the comments made by the board during deliberations, providing some background on the hearing. On May 12, 2026, the village board for the village of Short Hills convened for a public hearing pursuant to Wisconsin statute section 17.16 parent 3 to consider whether to remove village president John Ives from office based on the verified complaint by Brian Hutching and Peter Hans, which alleged President Ives should be removed from office for gross neglect of duty under Wisconsin statute 17.13 parent 2. Public hearing on Hutching and Hans' complaint was held at the village hall with 6 members of the village board participating in person and 1 attending via video conference. Mr. Ives was present and represented by attorney Aaron Deely. The complainants, Mr. Hutching and Mr. Hans, were present. Mr. Hutching also serves as a trustee on the village board. Complainants and respondents were provided an opportunity to make an opening statement which both exercised. Complainants then presented their case in chief and called 1 witness, Mr. Hutching, and offered 4 exhibits into the record. The village board received all the exhibits offered by the complainants. Respondent had the opportunity to cross-examine complainant's witness. After complainants concluded their case in chief, respondent presented their case, calling 2 witnesses, Mr. Ives and trustee Later, and offered 13 exhibits into the record. The village board received all of respondents' offered exhibits. Complainants had the opportunity to cross-examine each of respondents' witnesses. Parties were then provided an opportunity for closing statements, which both exercised. Based on its review of the complaint, the answer, the testimony of the witnesses, the exhibits received, and being fully advised, the village board now makes the following findings of fact. Number 1, President Ives received a profit and loss statement related to the Logic building the village was considering purchasing in 2025. President Ives received this profit and loss statement from Ava Kenny via email on September 3rd, 2025. He did not share the statement with village trustees. President Ives was aware that this profit and loss statement was necessary to the deliberation of the village trustees in considering the purchase of the Logic building, but yet did not provide it to them when the village was considering the purchase. Finding of fact number 2, President Ives intentionally used personal email accounts to conduct village business, which concealed records from public disclosure. President Ives was further non-responsive to public records requests. President Ives was advised to use his government email account for public business and failed to do so. Conclusions of law. President Ives' failure to provide the profit and loss statements related to the Logic building constitutes a material misstatement of relevant financial information and concealment of relevant financial information, which violates his fiduciary duty and duty of honesty in the conduct of public affairs. Number 2, President Ives' concealment of records from public disclosure violates his duty of honesty and transparency in the conduct of public affairs. Number 3, based on the foregoing findings of fact and conclusions of law, President Ives has grossly neglected his duties as village president as defined in Wisconsin statute section 17.13 parent 2. Order. For the reasons stated herein, the village board hereby orders the removal of President Ives from the office of village president in accordance with Wisconsin statute section 17.16. Adopted this 12th day of May by a vote of 4 in favor and 3 opposed.
So I make a motion to
Adopt this as the written statement if you so choose.
I'm going to make the motion to get it on the record. I make a motion to approve the written statement as read.
To adopt the written statement and the verb that we're.
To adopt the written statement.
Second.
Carol seconds. Is there anybody who wants to make any revisions or adjustments or changes? I'm going to look around the room. Seeing none, I'll call the vote. Do you need to, can
Let's just see what it is.
all in favor say aye?
Aye.
All opposed? The motion carries. Is there a motion to adjourn?
Motion to adjourn.
Second.
Rocky makes the motion to adjourn. Mark Letter seconds. All in favor say aye.
Aye.
The motion carries.
Thank you.
Steve.
Truly able
Yeah.
Hey, Ryan. So